Senate will come to order. The senators will please take their seats. The senators and all in attendance will please stand and be led in the invocation by the Honorable Mark J. Peake, 22nd Senatorial District. Following the invocation, all will please remain standing and be led in the Pledge of Allegiance to the flag of the United States of America by Corinne Sloan, Assistant Journal Clerk, Virginia Senate Clerk's Office.
Thank you, Mr. President. Let us pray. Our most gracious and heavenly Father, we give thanks for the opportunity to meet here today to serve the people of the Commonwealth. We ask for your guidance as we gather here to do the people's business. Please bless us with wisdom, patience, and understanding as we debate the important issues that face the Commonwealth during this critical time. We ask that you please continue to bless the Senate staff that works so hard to enable us to do the people's business. We ask that you continue to bless the Capitol Police who work so hard to protect us and keep us safe, and we ask that you please protect them and keep them safe and protect all of the law enforcement officers in the Commonwealth. We thank you, O Lord, for this opportunity for each and every one of us to serve as a representative and voice for the citizens of the Commonwealth. We ask you to please empower us to fulfill our awesome responsibilities with resolve, respect, and compassion. And finally, O Lord, we ask that you please continue to protect the men and women of our military who risk their lives every day to ensure that we remain the land of the free. In Jesus' name we pray. Amen.
To the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The clerk will call the roll. All those in attendance will please record their vote aye. Clerk will close the roll.
You have a quorum, Mr. President. Senate Journal for Tuesday, September the 15th, 2020.
The senator from James City County moves that the reading of the journal be waived. All in favor of waiving the reading of the journal will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 32, noes 4.
Ayes 32, noes 4. The reading of the journal is waived. The clerk will report any communication from the House of Delegates.
We do not have any, sir.
Thank you, Madam Clerk. Clerk will report any communication from the governor.
We still do not have one, sir.
Thank you, Madam Clerk. Is there any business to come before the Senate in the morning hour?
Mr. President.
For what purpose is the senior senator from Chesapeake, Senator Cosgrove, rise?
Mr. President, I ask that the journal reflect that the gentleman from Russell, Senator Chafin, is away on pressing personal business.
Thank the senator. The journal will so reflect. Senator from Henrico, Senator Donovan.
Thank you, Mr. President. I rise to request that the journal reflect that the senator from Washington is also away on pressing personal business.
Thank the senator. The journal will so reflect. The junior senator from Richmond City, Senator Morrissey.
Good morning, Mr. President. Thank you.
Good morning, Senator.
I rise for a point of order.
Senator, has the floor.
Thank you, Mr. President. Mr. President, at the end of the session yesterday, the senator from James City County broached the subject of protocol and titles, and I'm glad that he did. And then we got this purple sheet. So here's my inquiry. I noticed that, of course, there's lots of seniors and lots of juniors, and actually, I think it's pretty cool to be a junior. I noticed something interesting about Fairfax County, and because I, too, am interested in tradition, was wondering what the genesis of this is. We have a senior senator from Fairfax County, and that, of course, is Senator Saslaw. But there are no junior senators from Fairfax County. There are 5 other senators from Fairfax County, and they are from every quadrant: southern, northern, eastern, and western. And what I really love is the one from northwestern Fairfax County. So what would be the tradition and history behind no juniors from Fairfax County, but other juniors in the body? Thank you, Mr. President.
Thank the senator. I thank the senator for his inquiry. It actually is very timely. Beginning today, we're going to call Senator Saslaw the senator from Central Fairfax. So there's no more senior senator from Fairfax after today. I'm told that the genesis is that we have so many from Fairfax that there was a new way that needed to be distinguished to refer to each of the other members of the Senate from Fairfax. But also we'll call the senior senator from Fairfax, Senator Saslaw.
Mr. President, I would say to the junior senator from Richmond that what we call each other in Fairfax is none of his business.
Thank the senator. For what purpose does the senator from Fairfax City, Senator Peterson, rise?
Thank you, Mr. President. I rise to respond to the inquiry.
Senator has the floor.
Mr. President, years ago when I was serving in the other body as a freshman, I was introduced as the gentleman from Fairfax, and after the session was over, I went and spoke to the speaker, who was the gentleman from Amherst at that point, and told him that I was actually from Fairfax City, at which point he responded, "What's the difference?"
Thank the senator. Is there any other business to come before the Senate in the morning hour? Do any other senators wish to be recognized? Seeing none, the clerk will call the calendar.
Senate calendar for Wednesday, September the 16th, 2020. Uncontested calendar, Senate bill on third reading. Senate Bill 5014, a bill relating to minimum training standards for law enforcement officers, crisis intervention team training.
Senator from Roanoke City, Senator Edwards.
Mr. President, I move that Senate Bill 5014 pass.
Senator has the floor.
Mr. President, this is uncontested, and that it has to do with the Crisis Intervention Team program. It had an earlier fiscal impact that's been taken care of. Basically, what the bill does, it has 3 components. It provides for a module of principle-based training that is compulsory, minimum training standards, subsequent to becoming a law enforcement officer. The second is a module of principle-based training to be included as part of a basic training and for recertification. And the third component has to do with comprehensive advanced training for crisis intervention team programs, which is longer. The second, third, fourth component is a 40-hour program. The other 2 are 20-hour programs, and therefore there's minimal fiscal impact. It's extremely important. It's supported, as far as I know, by all law enforcement officers. I know the state police supported, the chiefs of police supported, and I would urge the body to vote in favor of this bill, Senate Bill 5014.
Mr.
Thank you,
President,
Mr. President.
Thank the senator. For what purpose, Senator from Rockingham, Senator Obenshain, rise.
the senior senator from Roanoke County yield for a question?
Senator from Roanoke City, Senator rise for a question.
City.
I am the senior and only senator from Roanoke City. There is a Roanoke County, by the way, which circles the city of Roanoke, but I live in Roanoke City. The Roanoke County senator is somewhere here.
Mr. President, what's the difference?
I'll be happy to give you a half-hour explanation. I know the people in Roanoke City love the people in Roanoke County, but I'm not so sure the people in Roanoke County always love the people in Roanoke City.
Mr. President,
Thank the Senator. Senator yields. Will Senator yield?
But I would ask if the senator would yield for a further question.
Senator yield.
I'll be happy to yield for further questions.
Senator yield. You have the floor.
Mr. President, with respect to this bill, I noticed on the front page of the Harrisonburg newspaper this morning, there is an article about crisis intervention and de-escalation training taking place, actually that was provided to the Harrisonburg Police Department, and it looks like this is a standard set of training that is regularly provided to at least the Harrisonburg Police Department. And my question is there a zero fiscal impact because police departments across the Commonwealth are already providing this training?
Senator has the floor.
I'll answer the question. About, last I heard, maybe 70% of law enforcement at the local level have crisis intervention team training, and the teams are a little more advanced in terms of training than the additional parts of this bill. So what this bill does is cover the entire state in terms of local governments. And it means that those that do not have a team, which is a more advanced program, at least get some training in crisis intervention programs. What the crisis intervention is, it teaches the law enforcement officers to detect signs and symptoms of mental illness. This is a huge problem, as we all know. We've seen recently something in Rochester, New York, about a man who was mentally ill, and he was outside in the snow, and he ended up dying because the law enforcement, apparently in that case, did not understand that he was mentally ill. And when mental illness is taught to law enforcement authorities, they can take appropriate remedial action, take a person to a mental health hospital, for example, as opposed to jail. And they can understand the behavior of people who are acting in an unusual kind of a way. And so this is what this training is. It's not routinely taught unless there's a team, a crisis intervention team 40-hour program that's being taught. What this does, it spreads it out so that even if you don't have a team, you get some training in any event. And it's my understanding the chiefs of the police, the Roanoke County police officer, for example, called me and said that the chief of police in Roanoke County said the chiefs of police throughout the Commonwealth support this particular bill. So it goes beyond just the team so that everybody at the local level is taught crisis intervention programs.
Mr. President, I would ask if the gentleman would yield for a further question.
Senator Yield.
Be glad to yield.
Senator Yield, you have the floor.
Mr. President, I appreciate the explanation, and I certainly support the goals of this, but my question relates to the, I guess, the financial burden. And I'm glad to hear that 70% of the law enforcement agencies in Virginia are providing this kind of training. And I would imagine that large law enforcement agencies like those in Roanoke City or Fairfax County can bear that financial burden. What I'm concerned about is I represent a number of small towns that may have 2 or 3 police officers employed. How are they to cover the cost of providing this training? Is this just something that they need to find somehow in their budget, or is this somehow going to be provided at a state level at the cost of Department of Criminal Justice Services, and they're going to eat this?
Senator has the floor.
Yeah, Mr. President, it's my understanding the Department of Criminal Justice Services is going to come up with a program. But keep in mind, even at the local level, they're being trained, and what it means is that 20 hours, which is about a half a week, would be required both at the basic training level and also at the recertification level. 20 hours each time. They're already getting some kind of training. This simply adds a part of this training. It won't require any additional time, I don't believe, at the local level. Maybe, I think I saw possibility of $250,000 a year, approximately. But it should not be of any significant additional funding at all, because they're already being trained. This is simply a module or a curriculum that's part of their existing training. So it shouldn't have any significant impact at all.
Thanks, Senator. Further question?
Mr. President, I thank the senior senator from Roanoke City.
Thank the senator. Thank you. For what purpose is the senator from Northern Chesapeake, Senator Spruill, rise?
Thank you, Mr. President. Point of inquiry.
Senator has the floor.
Mr. President, why on the third reading uncontested calendar? I thought on the uncontested calendar, third reading, that there was no debate, no question. So when did we start doing that? Usually on the third reading uncontested calendar, that all the questions stuff on the second reading. So why we start doing this on the third reading? So take the word uncontested off of this then. If we're going to ask questions on the second and third, then why we call it uncontested calendar? Take it off that.
I thank the senator. And this is the only bill on the uncontested calendar. We would normally block them if there were multiple, but it's still open for questions when senators have them.
Mr. President.
And also, just a point of clarification, it's on uncontested because there were no negative votes or abstentions in committee. So that's how it ends up on that particular calendar. But I thank the senator. Senator from Franklin County, Senator Stanley.
Yes, sir. Can Senate Bill 5014 come out of the block, please?
There's an objection, so it cannot. Do any other senators wish to be heard regarding Senate Bill 5014? Seeing none, the question is, shall Senate Bill 5014 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 37, noes 0.
Ayes 37, noes 0. Senate Bill 5014 passes.
Regular calendar, Senate bills on third reading. Senate Bill 5018, a bill relating to conditional release of geriatric or terminally ill prisoners.
Senator from Loudoun County, Senator Bell.
Thank you, Mr. President. We've debated this bill, and there's been quite a bit of interaction on it. Made it better as we've gone along, and I appreciate the inputs. I know we're still having discussions, and hopefully, we'll find ways to even make it better. But with that, I move passage of the bill.
Thank the senator. For what purpose is Senator from Hanover, Senator McDougal, rise?
Thank you, Mr. President. Mr. President, would the gentleman yield for a question?
Will the senator yield?
Yes, Mr. President.
Thanks, Senator. Senator yields. You have the floor.
Thank you, Mr. President. Mr. President, I asked the gentleman, as we went through, I think, a number of different modifications or redrafts of this bill, in the final version that's before us now, would a person who was convicted of their third, fourth, or fifth offense DUI be able to receive this early release?
Senator has the floor.
Mr. President, I will remind the gentleman this would change the existing code for compassionate release from 3 months to 12 months, and it would apply to Class 1 felons would be exempted, and it would be Murder 1 and Murder 2 exempted. So it would only be the case, to your question, if it fit into one of those categories.
Further question?
Mr. President, would the gentleman yield for a further question?
Senator yield?
I yield.
Senator yield, you have the floor.
So, Mr. President, I asked the gentleman, so if it would apply to the individual who had been convicted of multiple DUI felony offenses, would the early compassionate release also be able to apply to somebody who had been convicted of vehicular homicide, which is probably involuntarily manslaughter?
Senator has the floor.
Mr. President, I would again say it would depend on if it fed into they would have to be a Class 2 or below, and they would not be a Murder 1 or Murder 2.
So, Mr. President,
question?
would the gentleman yield for additional questions?
Senator yield.
Mr. President, I yield.
Senator Yield, you have the floor.
So, Mr. President, I'd ask the gentleman, since involuntary manslaughter is not a Class 1 or 2 felony, that would apply if the person had some sort of liver condition because of their alcohol consumption and made it terminal, would they be able to get this early compassionate release after one of those convictions?
Senator has the floor.
Mr. President, I would say if a person met the criteria of the bill, they would be eligible to be considered for parole. And in the case of a terminal illness, they would be eligible for consideration. Does not mean parole would be granted.
Mr. President, would the gentleman yield for one additional question?
Will Senator Yield?
I yield.
Senator Yield, you have the floor.
Mr. President, in the hypothetical of which I was moving forward on, if that individual had, say, a liver or kidney condition and they received a transplant, so they were terminal prior to the transplant, would that person then be reincarcerated or would they continue to remain out on parole?
Senator has the floor.
Thank you, Mr. President. In that hypothetical, the issue would be the terminal condition and the terminal diagnosis, and I believe it's an interesting point that the gentleman brings up. But the terminal diagnosis would be under consideration that a transplant would not be eligible. But as we go forward, this is something that we will continue to explore. I will tell you that the care plan, frankly, would only go to people who are within 12 months of, based on the diagnosis. And frankly, with the treatment that would be life-saving, it would not fit the criteria of the terminal illness.
Mr. President, speaking to the bill.
Senator has the floor.
Mr. President, I applaud the gentleman's efforts because I do think that this is an area that we do need to look at. But the way this is drafted, Mr. President, gives me some pretty significant concerns, particularly in the hypotheticals I've raised. Mr. President, in my experience, and we're all beneficiary of our experiences, as I mentioned yesterday, traditionally individuals that are convicted of multiple DUIs, particularly later in life, that is a very difficult challenge for them to overcome. And Mr. President, particularly ones who've been convicted of involuntary manslaughter as a result of consumption of alcohol would be eligible to be released at a very early age and still able to drive. The terminal determination is on life expectancy, not on their physical ability to actually interact or be in the public. So, Mr. President, as we are going forward, I'm going to vote against this bill today because I do think it raises some concerns that I think we should tighten up, not leave it to the parole board to do at a different point in time. Because, Mr. President, if somebody gets out early, does not complete their sentence, and kills somebody on the road, then we're going to have some culpability on that, and that's not something I feel comfortable with. Thank you, Mr. President.
Thank the senator. For what purpose is the senator from Eastern Fairfax, Senator Sarabel, want to be recognized? For what purpose is the senator from King George, Senator Stewart, rise?
Mr. President, would the gentleman yield for a question? Gentleman from Loudon, I apologize.
Yes. Will Senator yield?
I yield.
Senator Yield, you have the floor.
Thank you, Mr. President. First, I would apologize to the senator from Loudon for not bringing this up prior to session, but as a result of another bill today that we're going to look at, this came to my attention, and I would ask the gentleman, while I understand the purpose of this bill and if there's a prognosis that the person may die within a year, he's eliminated murder, but would this allow what I would call child predators and all the child predation offenses to be eligible for geriatric, for consideration by the parole board under this bill?
Senator has the floor.
Mr. President, the bill would allow for, other than a Class 1 felony and other than murder 1 or murder 2, and they would have to be, if it's someone who is 65 years age of over, served at least 5 years of the sentence, 60 years or older, and served at least 10 years, and who's terminally ill. The current code, I will remind the gentleman, actually allows for the same compassionate release at 3 months, and the difficulty there is getting a diagnosis and, frankly, getting the consideration before the person were to die. The 12 months is frankly to extend that. It's hard to get a diagnosis that's that accurate, and frankly, most of the people end up dying while they're incarcerated. This would allow us to have more time in that case and save the Commonwealth a great deal of money, and also, I believe, frankly, give people who have harmed others the chance to do amends. But I thank the gentleman for the question.
Other question?
The gentleman yield for one more question.
Will Senator yield?
I yield.
Senator Yield, you have the floor.
Thank you, Mr. President. And I just want to make sure I understand it, and I would further ask the gentleman. I don't believe that manufacturing, selling child pornography is a Class 1 misdemeanor. I could be wrong about that, and it certainly doesn't qualify as murder. And I don't believe felonious prostitution with a minor or using minors in a prostitution ring is a Class 1 felony. And so, do I understand it correctly that this bill would offer those offenders the ability to be considered for parole?
Senator has the floor.
What I would tell the gentleman is that it would offer consideration to those who are not Class 1 felons and are not convicted of murder 1 or murder 2.
I thank
and that's
the
where we
gentleman,
stop the consideration.
Thank you, Senator.
Mr. President,
Senator from Rockingham, Senator Obenshain.
would the senator from Loudoun yield for a question?
Will Senator yield?
I yield.
Senator yields. You have the floor.
Mr. President, I would ask the gentleman from Loudoun if I understood his response to the senator from Westmoreland to indicate that this parole eligibility for terminally ill inmates is restricted to inmates who are 60 or 65 years of age. Is that what the gentleman intended to say to the senator from Westmoreland?
Senator has the floor.
Thank you, Mr. President. To Senator from Rockingham, I will say on the bill, this is any person serving a sentence imposed upon a conviction for a felony offense other than a Class 1 or the amendments we made, murder 1, murder 2, who is 65 years of age or older, served at least 5 years of the sentence, or 60 years or older and has served at least 10 years.
Mr. President, further question.
Senator Yield?
I yield.
Senator Yield, you have the floor.
I would ask the gentleman from Loudoun if he would take a look at line 16 and tell us whether there is an or also before Romanet number 3, which would provide that this geriatric, or excuse me, the parole for terminally ill inmates is available irrespective of the age of the inmate.
Senator has the floor.
Mr. President, yes, the or does do that, and that is the entire compassionate release of the terminally ill. And again, it just changes it from 3 months to 12 months.
Well, speaking to the bill.
Senator has the floor.
And perhaps there is a disconnect here, but my understanding, at least initially and in response to the senator from Westmoreland's question, was that the compassionate release was available only to inmates who were terminally ill, who were over 60 years of age and served 10 years, or over 65 years of age and served 5 years. That's not what this bill provides. It does continue to provide that parole, the geriatric parole, but it provides also, not in conjunction with, but also the compassionate parole for somebody who is terminally ill, as the term is defined here, as somebody who is projected to have 12 months to live. You know, I look at this and I wonder and scratch my head as to who gets to make that determination as to whether they qualify for release under that provision. I thought that there was a little bit of reassurance because they had to be geriatric as well. I see that they do not have to be geriatric, and if somebody provides a medical opinion, I see no qualitative requirements as to what their qualifications are. They may provide some opinion that, yeah, this inmate has a year or less to live, and if the Department of Corrections, if the Commonwealth's attorney for a particular county says that's totally wrong and provides a medical opinion to the contrary, it would appear to me that the sole discretion lies in the hands of the parole board to make that determination. And I, for one, am not comfortable with giving that level of additional discretion to a parole board that has repeatedly demonstrated its disregard for their own rules and the requirements of state law. So, while I certainly want to provide a level of discretion with respect to compassionate cases, I think this gives a lot too much discretion to a parole board that has not demonstrated that it deserves this additional power. So while in other years I might have been inclined to have supported this, under the present circumstances, I can't support giving this parole board that additional power and discretion.
Thank the senator. For what purpose is the junior senator from Richmond City, Senator Morrissey, rise?
Thank you, Mr. President. Mr. President, would the senator from Hanover yield for a question?
Will Senator yield?
Yes, Mr. President.
The senator yields. You have the floor.
Mr. President, I'll preface my question that I understand exactly where the senator is going with his inquiry. The 42-year-old citizen who has 16 previous DUIs, is in DOC, is terminally ill, gets released, and has a miracle and survives and continues. I know where he's going with that example. Here's my question. I know the senator always does his homework. I've seen the senator in court. I know he always does his research. And I know the senator never asks a question that he doesn't already know the answer to. Can the senator tell us, after having done his homework and research, is he aware of one single example in the last quarter of a century where the Virginia Department of Parole released somebody on compassionate release because the individual was terminally ill or geriatric release, where that person went out and committed a single crime, even a minor misdemeanor? One case in the last quarter of a century.
Senator has the floor.
Mr. President, I would answer the gentleman. I think, as the senator from Loudoun indicated, the current restrictions on the time frame for terminally ill is prohibitive in allowing individuals to be released at all. So I don't know that there's a significant number that have been released under this section at all, and I do not have the exact number. But, Mr. President, the two concerns that I have are specifically related to vehicular homicide or driving under the influence with multiple felonies, is that a person has shown a reckless disregard to the public safety and to their own safety by continuing to drive after consuming self-intoxicated substances. So, Mr. President, as we have drafted this statute, and it is going to be very different than what we're currently operating under, there's going to be two ways an individual could have a lesser sentence than what they do now. One, as the senator from Harrisonburg articulated, they can be of a certain age, had a certain amount of time, and then be released, time less than what they were sentenced. Or, Mr. President, they could fall under the second section and be of any age and be released because of a terminal diagnosis or terminal indication by a medical professional. So, Mr. President, I would answer the gentleman's question specifically. The parameters by which we operate now are in no way similar to the parameters that we will be operating under going forward if this bill is to pass. So I don't think a past history is any indication of future potential results.
I thank the senator. Speaking briefly, Mr. President.
Senator has the floor.
I want to address one inquiry that the senator from Rockingham brought up, and that is the situation where a individual is terminally ill. He was correct in that there are two prongs of this bill, so to speak. One, geriatric release because of age, and then another one, release irrespective of age but due to being terminally ill. The senator from Rockingham brought up the point that he felt that the Virginia Parole Board would be having too much discretion. Here's the point. The Virginia Parole Board is not sitting up there when they're deciding whether somebody is going to be paroled and opining among themselves whether this person is terminally ill. It only comes to them if they have a report from the medical division of DOC saying, quote, this person is terminally ill and has X months to live. So there's no broad discretion that the senator from Rockingham referred to in the Virginia Parole Board granting release because of terminal illness. They are not determining terminal illness. That's been done before them. They receive the report and they make their ruling. Thank you, Mr. President.
Mr. President.
And Senator from Rockingham, Senator Obenshain.
I would ask the junior senator for the city of Richmond if he would yield for a question.
Will Senator yield?
I yield, Mr. President.
Senator yield. You have the floor.
Mr. President, while referencing lines 11 through 12 of the bill, I would ask the senator from the city of Richmond if he would tell me where exactly the bill says that the diagnosis or the prognosis of a terminal condition has to come from the Department of Corrections or its medical staff.
Senator has the floor.
It does not say in the bill, the 21-line bill, that it comes from DOC staff. Lines 11 and, in my PDF form, 12 and 13 refers to defining terminally ill, having a chronic or progressive medical conditions caused by injury, disease, or illness where the medical prognosis is the person's death within 12 months. As the senator from Rockingham knows, that's not something that's done willy-nilly by a DOC corrections officer who goes in and says, you know, I think this person is terminally ill, and I'm going to write that down. As the senator from Rockingham knows, there is an entire department, a medical division within DOC, and those are the individuals, those physicians that would opine as to the person's terminal illness. So, in conclusion or summary, it doesn't say that in the bill that you have to get a medical report of terminal illness, but I think it is very clear from the verbiage that that's what we're talking about.
Mr. President, I thank the gentleman. I would ask if he would yield for a further question.
Senator yield.
I yield, Mr. President.
Senator yields. You have the floor.
Mr. President, I think members of the legal profession are familiar with medical record reviews, situations in which lawyers or their clients seek a doctor to simply look at the medical records of somebody and to render an opinion. Is there anything in lines 11 or 12 or anywhere in this bill that would prevent an inmate, his or her family, or his or her lawyer from securing copies of that inmate's medical records from the Department of Corrections, securing a medical record review, and having that paid doctor provide a prognosis to the parole board saying, my client is terminally ill, and having the parole board make a decision on the basis of that paid opinion by a doctor retained on behalf of an inmate.
Senator has the floor.
I would respectfully say that it doesn't say anywhere in this bill whether or not a loved one can inquire and get medical documents. With that said, I can tell the senator from Rockingham that many times, dozens, multiple dozens, I've inquired about the medical health of an inmate. I have opined in my letter as their defendant's attorney as to their condition, which was given to me by the family member, and on every occasion, they have said, we will bring him to the medical department, we will have him examined, we will do that. Secondly, I am not aware of any instance where the Department of Corrections, upon request, mailed the current medical condition of the inmate to either the defendant's lawyer or to his family member.
Mr. President, further question.
Senator yield.
Yes, Mr. President, I yield.
Senator yield. You have the floor.
Mr. President, as somebody who has represented law enforcement, including the Department of Corrections, in many cases involving questions about inmates' medical conditions, would the senator not agree that if there were a Section 1983 claim filed on behalf of an inmate, that in conjunction with that action, the inmate or his or her attorney could subpoena from the Department of Corrections their medical records and then provide them to a healthcare provider?
Senator has the floor.
I would tell the senator that that seems logical, and that appears that could be done.
Further question?
Senator Yield.
And that once a lawyer or an inmate obtained their medical records, there's nothing in this bill that would prevent that inmate from getting that paid medical opinion from some doctor retained, and who could then provide that opinion to the Department of Corrections and the parole board and secure their release. Correct?
I would tell the senator that once the inmate's physician or lawyer got the records and then he sent them out to another doctor, I would agree that he could get an opinion. But I would also say that I would believe that Dr. Donovan or any of her colleagues in the Commonwealth of Virginia, I do not believe they would fabricate a report and say that the person is terminally ill unless and until they were assured of that. And I further believe if that doctor sent a letter to DOC and said, listen, I believe that your inmate is terminally ill, I think it would be incumbent upon DOC's own medical staff to verify that.
Mr. President, further question.
Senator Yield.
Senator Yields.
Senator Yield, you have the floor.
But my question would be, isn't it true that the decision-making authority under this bill doesn't lie with DOC, but with the parole board, and that they're the ones who get to decide how much weight to put on that paid medical report of that retained doctor who may just have a different opinion from the doctor from the Department of Corrections?
Senator has the floor.
I would tell the senator that he keeps referring to that paid medical report, which is a suggestion that it is bought and paid for. I get that. But I keep reminding the senator from Rockingham that I believe the member of the Virginia Parole Board would have an accompanying document from DOC that says, yes, we also have examined the inmate and we agree that he is terminally ill. And I would agree with the senator from Rockingham that the ultimate decision making is done by the Virginia Parole Board.
I thank this senator.
Thank you, Senator. What purpose is Senator from Eastern Fairfax? Senator Surville rise.
Speaking of the bill.
Senator has the floor.
Thank you, Mr. President. Ladies and gentlemen, I'm going to talk really quick about this bill, which passed with almost no debate 2 years ago. Talk about a little history. When this bill first came through the Courts of Justice Committees, it was then called back in 2019. My recollection is it originally had the disabled prisoner language in it, which was removed at the request of the Virginia Commonwealth Attorneys Association. And I believe at the time somebody asked, I think I asked the Secretary of Public Safety, how much money would that cost us? It was $29 million by making that amendment. We made the amendment again this year, and now we further scoped this bill back narrower than the bill we passed in 2019, and now there's apparently problems with it. I would note that in 2019, this bill had 11 no votes. 2 of the no votes were replaced by Democratic senators. 1 has retired, and another one has retired, and his successor is not here. And so amongst the remaining 7 senators who voted no, none of them have spoken yet. But apparently some other folks have changed their minds in the meantime, and I guess people are entitled to change their minds. And I'll take the gentleman's word for it that the things happened at the parole board lately that have changed their point of view. But at some point, you got to trust the system we set up. I mean, we have a parole board that's set up to make these decisions. It's worked for decades. It works now. We just made some more amendments, which I think will make it even stronger. And by just restricting and further restricting these types of opportunities to give terminally ill people parole, all we're doing is costing taxpayers money and forcing the governor to pardon people instead of putting them through a much more transparent process where there can be input and victims can have their say and decisions can be made properly. I mean, Mr. President, this bill, has caught 30 minutes of heat on the floor, whereas 2 years ago it went through, I think, without a single debate, without any debate at all. And I think we need to move this debate along and pass this bill.
Mr. President.
Thank you, Senator. For what purpose, Senator from King George? Senator Stewart, rise.
Would the senator from Eastern Fairfax yield for a question?
Senator yield.
I'll yield.
Senator yield, you have the floor.
Mr. President, I actually was one of those senators, I think, that supported this some time ago. And what's given me pause is this, and I'll ask this in the form of a question. If I read this properly, I ask the gentleman from Eastern Fairfax, if a 40-year-old child rapist or a 40-year-old that was producing child pornography or a 40-year-old that had a human trafficking ring and was convicted of such, under this bill, could that individual who is only 40 years old, having been convicted of one or more of those offenses and obtained whatever this loosely determined medical prognosis is, and it is not defined in this bill very well, and I think the gentleman has to agree with that. Would not that 40-year-old convicted of what I call very serious child predation crimes be eligible for parole under this bill?
Senator has the floor.
Thank you, Mr. President. First of all, I want to thank the gentleman for correcting me for the second day in a row, or not by him, but it's a second correction because he was actually a no vote in 2019.
Okay.
And so he's consistent, I would just note.
Thank you.
But secondly, I think his reading of the bill is correct, that such a person or such a person convicted of that would be eligible. And I would trust that if the person was still deemed to be a threat to the public and the parole board would feel that they have not been rehabilitated or their crime was so serious that they would continue to be a threat to the public if released, the parole board then wouldn't release them. So that's, at some point, you got to trust our system to work, and that's why we have a parole board.
Further question?
Mr. President, actually, I'd like an opportunity to speak to this at the appropriate time.
Senator can do it now, if you like.
Thank you, Mr.
Senator has the
President.
floor.
Mr. President, the more I read this bill, the more it concerns me, and here's why. One of our primary responsibilities in this body is public safety, to protect our citizens, to make our citizens safe, and we've had a lot of discussion about that and ways to do that in this special session, and we've been talking about that ever since I came to the General Assembly. But for us to entertain a bill that allows child predators, and I consider child predators to be the worst of the worst, and I doubt there's anybody in here who disagree with me on that, because we all love children, our children, other people's children, and we all have a responsibility to protect them from people that would harm them. And these are the people that would harm them. And I've dealt with them as a Commonwealth's attorney, and I've dealt with them as a prosecutor. And a lot of these people you can't help. And a lot of these people don't change the way they look at the world and the way that they want to hurt these children. And to me, this would be the ultimate in shirking our responsibility in protecting those young people from these predators. They can do a hell of a lot of damage in 12 months. And that's assuming that the 12 months is a correct prognosis. There's no definition in this bill as to what a medical prognosis is, who has to make that. It's very loosely framed within this bill, and I just hope everybody will give that a great deal of consideration. This is not a partisan issue. This is about looking after the folks in our community who really need to be looked after, and those are the children, and trying to keep these predators away from them. Thank you, Mr. President.
Thank you, Senator. What purpose, Senator from James City County? Senator Norman, rise.
Mr. President, speaking to the bill.
Senator has the floor.
A couple of bullet points. First of all, about trusting the system. I think it's important to be mindful that we in the legislative branch frequently define what the parameters and the objectives of the system is, and that's what we're talking about today. Number two, we spent about 20 minutes debating back and forth, which I attributed as an inadvertent misstatement of what was in the bill. I would say to this, and following on what the senator from King George said, is that one of the concerns that I have, and the sponsor of the bill repeatedly said that if you were a Class 1 or Class 2 felon, that you were excluded from the situation. The senator from Prince George is moving, I think, in a very important direction as he tries to shed some light on it. I think some members who are not attorneys, and consider yourself blessed, that if you look at some of the sections dealing with pedophiles, such as Section 18263, which talks about carnal knowledge with a child between the age of 13 and 15, that is a Class 4 felony. And that is someone that would be eligible for this geriatric release under the current language of the statute. I would say that there are a number of senators in this room that previously have visited the facility which incarcerates these sex offenders. And one of the things that any of us who have looked at pedophiles or sex offenders know that the probability of rehabilitation is slightly more than zero. Slightly more than zero. And if you look at the numbers of those who have been released and not reoffended from the sexual offender venue of incarceration, it substantiates that. So when I start thinking about balancing the public safety against how much it is going to cost to keep this person in prison, or how compassionate we should be, perhaps I am calloused in indifference. I have no compassion for a pedophile. Zero. Because the probability of rehabilitating them against their predilections is zero. So I suggest to you, Mr. President, I don't care what the vote was 2 years ago. What I care about is what this corporate body is going to decide today. And I suggest to you that with not questioning the intentions of the sponsor of the bill, it remains too broad in those individuals that compassion, forgiveness is going to be extended who have a high probability of reoffending.
Thank the senator. For what purpose, Senator from Henrico? Senator Dunham, rise.
Thank you, Mr. President. Speak to the bill.
Senator has the floor.
I just wanted to weigh in. There had been some reference points, and I would say I am very empathetic and supportive of legislation that would seek to release terminally ill individuals who have less than a year to live. And I think that is an appropriate thing for us to do from a humanistic standpoint as well as a fiscal standpoint. But my problem with the bill, and as usual I've lost it on my site here, so I'll need to sign in again, is the lines that make it easier for the other population to seek parole even without a request. I have a problem with that. I think this bill has confounded two issues that should be considered separately, and I can't support the bill that I would like to because it's combined with those other aspects. So really, without getting to the line in the bill, Mr. President, that's what I wanted to say. It's frustrating when we have bills like this that have some noble components to them that are confounded with other things that make it impossible to support the bill. Thank you, Mr. President.
Thank the senator. For what purpose is the senator from Arlington? Senator Favola, rise.
Thank you, Mr. President. I rise to speak to the bill.
Senator has the floor.
Thank you, Mr. President. My goodness, this bill is really very straightforward and I think very needed. I'm a little surprised at the debate that's going on. Rehab and Social Services heard the bill, and I just want to point out a couple of things. And I'm sure that the many astute attorneys in this body have already done research during this debate, but the Virginia Parole Board has a very extensive manual with many steps to determine whether or not a offender is actually to be considered terminally ill. The two physician reports are required. Only one physician can be employed by the Department of Corrections. There's a very extensive report that the physicians must complete. So it looks like there are protections to ensure that adequate medical information is provided to the parole board. Step one. Step two, that only makes the offender eligible for the parole board to then apply any other criteria they think might be necessary for the release of an offender. I think the point was made by the senator from Eastern Fairfax. If the offender would be deemed to be a threat to society, the parole board would not release the offender. The purpose of this bill is if all other criteria are met, in other words, safety, the offender has a plan, a home to go to, or a nursing home, skilled nursing facility to go to, wherever that person needs to go. The purpose of this bill is to allow an individual to die some other place than jail. That is the purpose. And we are trusting a system which I think has a lot of belts and suspenders with lots of procedures, multiple pages here, on how the parole board exercises its discretion in granting the parole. And as you know, it says on line 18, the parole board can promulgate further regulations. So I think we have to allow this to go forward. There may be other tweaks we make in the future, but this bill in its heart and soul is worth voting for. I think we all want to be compassionate here, and I think we need to keep this bill in context. I ask that the body vote for it.
Thank the senator. For what purpose, Senator from Bedford? Senator Newman, rise.
Mr. President, speak briefly to the bill.
Senator's floor.
Mr. President, I find myself in an odd position in this bill. One, I very much want to vote for this bill. I do believe that we have erred with the 3 months. I agree with the 12 months. I believe that an individual that is truly terminally ill should have an opportunity to spend his final days with his loved ones. Mr. President, I also want to thank the gentleman from Loudoun. He's brought forward a bill that's not easy to bring forward. He has worked diligently on the bill. He's made adjustment after adjustment after adjustment. The difficulty here is that we really need a few more days, and I think that we could end up with broad support. I think some of the items that have been brought up today, I think, are not best left with the parole board. My problem really with what's left of the bill is really on line 20 and 21, and all the regulations as related to this section of the code is promulgated by one group, and that is the parole board. So the parole board is the one that promulgates all the regulation on the medical items, on how the doctors are process will come through, and then the parole board makes the decision. We can do this, and I think the senator from Loudoun has set us on a path to do this in a better way, to deal with the issues that have been brought up by the senator from King George and others. But I think we need to do this, whether we do it today or another day. We need to do this, but we need to do it right. I think we're very, very close with a bill like this to actually exempting out a number of the things that were discussed, including the drunk drivers and others. So I hope that we will show more compassion on these sides. I'm grateful for the senator from Loudoun for bringing the bill forward. I just hope that between now and maybe the end of this process, we can exempt out these things that we're very concerned about and also give guidance to the board who's going to promulgate the regulation. Thank you, Mr. President.
Thank the senator. For what purpose, the senator from Franklin County, Senator Stanley, rise.
Thank you, Mr. President. Speak against the bill.
Thank you, Senator. You have the floor.
Mr. President, been here 4 weeks now. Quite frankly, when I was looking at my calendar, if this was the short session that starts in January, which is fast approaching on us, I would have thought we're past crossover. And when I came here, I understood that the topics were pretty simple, straightforward. Social justice reform, police reform, and the budget. Let me repeat those just so everybody remembers. Social justice reform, police reform, and the budget. Well, tell me this. What in good gravy does this bill have to do with social justice reform, police reform, or the budget? What does letting a convicted pedophile who has hurt a child in the Commonwealth of Virginia and probably affected them for the rest of their life, what does letting that pedophile out have to do with social justice reform, police reform, or the budget? In fact, I would submit to members of this body, if you look at this bill, with the release of a convicted pedophile, murderer, that we probably aren't doing very good social justice reform, because most likely, ladies and gentlemen, we're doing things that are going to hurt the community where that convicted pedophile is now released back into. So you come up here and you want to talk about social justice reform, but well, I'm telling you right now, in practice, that is against what you guys are preaching and practicing that you want to do. And quite frankly, again, we hear another bill that you guys passed, just like local option enabling legislation. It doesn't really do what it says. It's not going to be that bad. Localities won't pass it. I'm hearing in this debate that, oh, don't worry, the parole board, this just allows them to do it. But then there are other criteria. There's 2 doctors who exist, and there's that. After what I've seen lately about with our parole board and releasing murderers, cop killers, I have absolutely no confidence in what you say that, well, this allows this to happen, but it really won't happen. It's not as bad as you guys are making it out to be. What in the world, what in the wide, wide world of sports does this bill that will release a convicted pedophile who committed a violent act against a child have to do with social justice reform, police reform, and the budget? And my answer, which I don't need any of you all to answer on the other side of the aisle, is it doesn't have a darn thing to do with any of those topics. Thank you, Mr. President.
Mr. President.
For purpose, Senator from Eastern Fairfax. Senator Sarville.
Will the senator from Franklin County yield for a question?
Will Senator yield?
I never pass up an opportunity to try to answer one of your questions. The senator from northeasterly corner of Fairfax.
Senator Yields, you have the floor.
Thank you, Mr. President. And I would just first note that social justice reform was not part of the Senate's proposed procedural resolution. That was what the House wanted, but that was not in our version, which is probably partly why we don't have a resolution. But I just wanted to ask the senator, under today's law, as it currently stands, could a convicted pedophile get geriatric parole once he turns 65?
Senator has the floor.
Mr. President, I would answer the gentleman by saying, first, quite frankly, with all the bills that I've seen come through this body, if they may not have put it on a piece of paper that we're here for social justice reform, we're here for social justice reform, not this. Second, I would state to the gentleman who I know is very familiar with the code that I'm not familiar with the code, to be able to adequately answer him with any knowledge that I possess of whether that is possible or not. So I can't give you that answer.
Mr. President.
Further question?
Could the gentleman yield for another question?
Senator Yield?
Yes, Mr. President, I'll yield.
Senator Yields, you have the floor.
Thank you, Mr. President. I know that the gentleman, being an attorney, is very astute and reads all these bills before we pass them and probably has the draft of the text right in front of him, given that we're debating it. And I would just ask him, if you delete all the amendments that are proposed to this code section we're talking about amending right now, the one that's right in front of us right now, that language, isn't it correct that a child pedophile, a person convicted of pedophilia or child pornography manufacturing or whatever, could apply for geriatric parole under the section 53.140.01 today? It's right there. You can read it.
Senator has the floor.
Mr. President, I'm going to assume that's a rhetorical question asked by my friend, the senator from southeastern, southwestern, northern junior Fairfax. And
just don't call me late for dinner.
Quite frankly, I decided for myself after reading it more than a couple nights ago that I needed no more education on this before I decided that it is a horrendous bill in the continuation of many horrendous bills that I have seen while being here for 4 weeks in this special session. Thank you, Mr. President.
Thank the Senator. Further question?
No, I thank the gentleman for being consistent with his vote from 2019, at least, Mr. President.
Thank the senator. For what purpose is the senior senator from Virginia Beach, Senator D. Steph, rise?
Mr. President, to speak on this bill.
Senator, has the floor.
Mr. President, I've spent a little time looking at this bill, not just in 2019 when I voted against it and discussed it on the floor back then, but again this time. And the same problems I had then are the same problems I have now. Now, lawyers are well educated. They go to school for a long time, and they're supposed to have a better grasp of the English language than most of us, because and, or, if, not, nor. But on the engineering side, we understand that too as absolutes. And in this bill, it talks about the geriatric release of 65 and 60, or who is terminally ill. And Mr. President, when we talk about terminally ill, I've had a lot of friends who have been told they have less than 6 months to live. And Mr. President, some of them, that was 10 or 12 years ago. Heck, one of them, it was 15 years ago. Mr. President, the way this is written, and I applaud the gentleman from Loudoun County on this. He did his best to try to make everybody happy. But every once in a while, when you try to make everybody happy, you really don't do a good job of it. If a 40-year-old with a letter from, and it doesn't even have to be a doctor, it can be anyone in the medical profession who says that he has less than 12 months to live. And he has a progressive type of illness that gives him less than 12 months to live. Well, Mr. President, there's a lot of progressive illnesses, and I've got a lot of friends who were told that they had less than 12 months to live 15 years ago. And Mr. President, we say that we have confidence in the parole board to do the right thing. Well, frankly, Mr. President, I don't have confidence in them. When we release somebody who has been given 3 life sentences plus 118 years, and we release others, and according to the parole board's charter, they're supposed to release people who are no longer a threat to society. No longer a threat. And we release one gentleman, as soon as he's out, within 60 days he's arrested again, and then arrested again. We release another one that they hunt down their victim that they raped, and then they kill him. And Mr. President, is that somebody who's safe to release back to society? What are we thinking? I have zero confidence in our parole board. And in the past, our parole board has not just ignored their policies and our laws, but they've continually released people who are a threat to our society. Now, I agree with compassion. We should have compassion toward our fellow citizen and everybody else out there. But I have more compassion for the victims of these crimes, and some of them multiple-time victims of these crimes, who are no longer with us because we released the person who raped them the first time, and then they killed him. And Mr. President, I don't know what some of the folks in the majority are thinking, but when you let cold-blooded killers out, murderers, rapists, child sexual predators, child rapists, and I say again, child rapists, and we've let people out who've raped babies, Mr. President. There is an egregious disregard for our law-abiding citizens. Egregious. We are putting these people back into society. Our job is supposed to be the safety and security of our citizens. When we release these people back out into society, to our society, and you can't tell me that they're all reformed. There's no way you're going to tell me that. Mr. President, we're releasing these cold-blooded killers, these rapists, these child sexual predators back into our community to continue the carnage, to continue what they've done. There's no way that we're looking for the safety and security of our citizens, let alone the victims who were originally the ones that were hurt in these heinous crimes. Mr. President, I've given example after example after example since we've been back for the last month. Mr. President, I think it's time we say enough is enough. And on Senate Bill 1786 from 2019, I was a no vote on that. And I spoke against that. And there's no way in heck I would support this or support that. When we give somebody life 3 lives plus 118 years, that should send a signal to the parole board. Don't release these people. What more do we have to say when we're sentencing people like that, Mr. President? How else are we going to take care of our citizens and look after the safety and security of them and be compassionate for the victims of these horrible, heinous crimes? We're setting the structure to allow for the release of more of these people, more of these criminals. And Mr. President, I've had enough of it. We've got to lock them down and keep them there. Thank you very much. And I'm sorry to impose on our time yet again with my compassion toward the victims and focused on the safety and security of our citizens. Enough is enough. Let's do the right thing. This is a bad idea in 2019, and it's still a bad idea today. Thank you.
Thank the senator. For what purpose, the senator from Augusta? Senator Hanger rise.
I'd like to speak to the bill.
Senator's the floor.
Thank you. Actually, I'd like to test my microphone to see if it works. I've not engaged in too much of the debate so far, and a part of that reason was not that I didn't have anything that I could have said. It's just that the issues were being framed adequately, and I was one who came here, like the senator from Franklin made his point about why we were here. I came here to work on the budget. And I had kind of had in my mind in coming here, even though other issues were being raised, that I was going to vote against anything that didn't have to do with the budget. Well, I've already violated that some, and I've already voted against a couple of bills that had merit that I thought could have appropriately been discussed in regular session and maybe vetted a little further, and I would have been comfortable voting for them. On this one, I came here today not conflicted at all on this bill. I thought I'd already voted for it in committee after we fixed it in the Finance Committee. I thought it was further refined on the floor here on second reading. And I guess it's one of those issues where when you embrace a concept, then you're more inclined to stay with it. And I apologize because I know there are a lot of members of my side of the aisle that have raised valid points of concern, and others on the other side that have raised issues of support. But here's where I'm at. I carried the original legislation for geriatric release probably 18, 20 years ago. And the concern that I've had over the years, has been that it has not been used enough. That we have had people remaining in prison on the tab for the taxpayers that have been there a long time. They're no longer a threat to society, and they're not a danger to society, but we're mad at them still. And I think we have to separate that out a little bit. If we're mad at pedophiles, we need to recognize the society that we live in cultures a lot of pedophiles, and most of them aren't in prison. They haven't been caught. They're out there still messing with children, and we need to work on that more adequately. But what we're talking about right now, just to refocus, are terminally ill prisoners that are extremely costly for our budget and for our taxpayers. I worked on a couple of cases just in this past year. One where it took actually a couple of months to get someone. The governor has this ability now within certain defined parameters, and got the governor to release someone who was being housed not in the prison but over at VCU in intensive care, and we were able to get that individual out to be at home for 3 weeks before they died. That's where we're at. Now, there may be errors in judgment. Someone who is terminally ill, rated as terminally ill, incapable of being a threat to society, may actually get out, but probably not. They're generally pretty careful in these things, even under the circumstances right now, which I understand. We're upset with our parole board, who's done some things recently that I don't agree with, many of us don't agree with, and perhaps we want some new members on the parole board. But that's not what this is about. This is about policy that I think perhaps, as the senator from Bedford has indicated, could be refined a little further. And I would hope that if there are suggestions that in the process that could be taken care of. But I do intend to vote for the bill. Thank you, Mr. President.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5018? Senator from Loudoun County, Senator Bell.
Thank you, Mr. President. You know, it's been a great debate. I have to call out the junior senator from Chesterfield who didn't say anything on this, but I call her out because, as she pointed out an error yesterday, I point out one that I was looking to see if this bill's debate could last longer than hers yesterday, and we're so close. If I read Green Eggs and Ham, I think we'll make it. It's been a great debate, and I think when we change the code, particularly on something as serious as this, we should have a good debate. And as one of my quoting heroes, Yogi Berra, said, "It ain't over till it's over." Well, I'm going to move passage of this bill today. As you know, we have more bites at this apple, and I'll continue to work at it. I hear some of the concerns, and I'll tell you, my door, my phone, they're open. I will continue to work on this because I want to make the best piece of legislation we can to do the right thing. What I will say is there's been a few things that I want to clarify. First, this bill only creates a mechanism for the parole board to consider release. It doesn't grant anyone release, doesn't guarantee release, just creates that ability. It allows the parole board really to review additional cases of terminally ill people. We talked about geriatric, that's already in the code. That was already there. This bill only goes to the terminally ill. So if you have a problem with the geriatric, that's a separate piece of legislation. It's not this one. Currently, if you're terminally ill, you have no mechanism to be considered for release unless you're over the age of 60 or 65, depending on how much you've served. I will point you out to a JLARC study, which was on this very issue, and it recommended moving from 3 months to 12 months, mainly because of the issues with how accurate that diagnosis can be. On the diagnosis, I have faith in the medical community. I have faith in the medical community. Giving a false diagnosis would be medical malpractice. That's a serious issue. I don't think when we make a terminal diagnosis, take that lightly. And the parole board, again, would only consider. The past history on this, many people who have applied who are in that very narrow window haven't gotten this release. Because the key point, which I want to make again, is that this person would pose no threat to public safety. And there are a number of safeguards in there that would make sure that this is the case. The last thing I want to point out is that most of the people who are in this terminally ill case, this situation, are bedridden. 80% are 100% bedridden. So these are not folks who are going to be active and going all over the place. These are people who are in the last days of their life. I'm hoping they can make amends to those that they've harmed, which is also their family members who've had to endure whatever situation brought them to the place they're at. I believe compassion is the right thing to do. It does save a great deal of money, has a budget impact. And if you're terminally ill in today's world and COVID is a present, which we know it is in many of our jails, that's almost an immediate death sentence. So it is relevant to this session. The last thing I'm going to say, this bill is consistent with the recently passed federal criminal justice reform, the 2018 First Step Act. President Trump said that should be the standard we set across the country. This bill is in alignment with that. And with that, I move passage of this bill.
Thank the senator. Question is, shall Senate Bill 5018 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 22, noes 15.
Ayes 22, noes 15. Senate Bill 5018 passes.
Senate Bill 5017, a bill relating to local correctional facility definition.
Senator from Northwestern Fairfax, Senator Boysko.
Thank you, Mr. President. Yesterday we amended this bill, and I move the bill pass. And speaking to the bill.
Senator has the floor.
Thank you, Mr. President. SB 5017 will change the definition of the 2 facilities that are currently contracted by federal ICE as local correctional facilities. This will, in fact, allow the State Board of Local and Regional Jails to set minimum standards for sanitation and allow for unannounced inspections. It will allow the board to prohibit confinement and require transfer of prisoners in what they find to be a substandard facility. It will allow the board to review the death of an inmate, and it will allow access to the interior of a facility by governing bodies. As everybody in this room is aware, we've had a massive outbreak in the Farmville location, where roughly 90% of the inmates and many of the guards came down with COVID-19. In just the past day, we have seen that there is an outbreak at the Caroline County facility now. And if anybody has been paying attention to the news nationwide, we have seen egregious and horrible stories of ICE facilities in other states. This bill will give us the teeth to allow our people to go in and make sure that they are being maintained in a proper sanitation, get inspectors in, and I move the bill pass.
Thank the senator. For what purpose is Senator from Lynchburg, Senator Peake, rise?
Thank you, Mr. President, and I want to thank the senator from Northwestern Fairfax for making the change to the bill that should hopefully take the town of Farmville out when the lawsuit occurs. And the senator from Arlington, I appreciate your work on that with the amendment. Thank the senator from Fairfax, Senator Marsden, for his help in trying to change it. And I appreciate the concerns with ICE. I would say that is a national level issue. We need to talk to your Congress folks, your senators, and work on that. My concern is that we have 2 facilities here in Virginia. They're in rural areas, 240 people employed at the Farmville facility. It brings millions of dollars into the local economy, and I'm concerned that by trying to control ICE at the state level, interfering with our federal preemption laws, that we could risk losing all those jobs in Farmville, and that's why I will vote against the bill, but I do appreciate the work that was done to try and limit the damage, but I'd rather do no damage at all. Let's ask you to vote against the bill.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5017? Seeing none, the question is, shall Senate Bill 5017 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 21, noes 16.
Ayes 21, no 16. Senate Bill 5017 passes.
Senate Bill 5034, a bill relating to release of prisoners.
Senator from Northwestern Fairfax, Senator Boysko.
Thank you, Mr. President. SB 5034 will increase the number of days an inmate increase the number of sentence credits an inmate can earn by participating fully in the rehabilitation programs and good behavior. Currently, all incarcerated individuals have the opportunity to earn 4.5 days per 30 days. This substitute excludes violent crimes. They increase the maximum number of credits to a total of 15 days, the nonviolent criminals. And this would create a work group to study implementation of this piece of legislation. It also contains the same bill that my good friend from Loudoun County, which we just spent 2 hours discussing and debating for compassionate release. And the implementation will go into effect in 2022 in order for us to make sure that we're being fiscally responsible. And I move the bill pass.
Thank the senator. For what purpose the senator from Hanover, Senator McDougal, rise?
Thank you, Mr. President. Mr. President, would Senator yield for a question?
Senator Yield.
Mr. President, I yield.
Senator Yield, you have the floor.
Mr. President, I would ask the senator if you are convicted of a DUI felony offense, would you be eligible for this early release credit if you met the other requirements of the legislation?
Senator has the floor.
Mr. President, if you comply with the behavior requirements and all of the provisions stated out in this bill, then yes, you would.
Further
Mr.
question?
President, would the senator yield for additional question?
Yes,
Senator
sir.
Yield.
Yes, sir.
Senator Yield, you have the floor.
Mr. President, if you were convicted of gang-related offenses, would you be eligible for this early credit?
Mr. President.
With the other requirements in the correctional facility?
Senator has the floor.
Mr. President, I'm sorry, I didn't hear the question fully.
Sorry, Senator, repeat the question.
Mr. President, I asked the senator, if you are convicted of gang-related offenses, would you be eligible for the early credits otherwise described in the legislation if you meet the DOC requirements?
Senator has the floor.
Mr. President, as long as it's a nonviolent offense, yes, sir.
Further question?
Mr. President, would the senator yield for additional questions?
Yes,
Senator
sir.
Yield. Senator Yield, you have the floor.
Mr. President, if you were convicted of a terrorism-related offense, same question, would you be eligible for these early release credits otherwise described in the bill?
Senator has the floor.
Mr. President, I will help my colleague from Hanover County understand. Offenses in 18.2, Chapter 4, crimes against person are omitted from this. Mob-related felonies, kidnapping, abduction, any sort of a murder, malicious felonious assault, or malicious wounding, robbery under 18.2.58, carjacking, criminal sexual assault, Article 7 penalties dealing with sex crimes, arson, Chapter 18.2 crimes against moral indecency, commercial trafficking, prostitution, crimes of obscenity relating to children are all excluded from this. The intent of the bill was to exclude violent felonies and crimes against children.
Further question?
Mr. President, yes, additional question.
Senator Yield.
Yes, sir.
Senator Yield, you have the floor.
Mr. President, I understand the senator's intent in this bill, but as I read the bill, I'd ask if a DUI felony is eligible for these offenses, if gang-related offenses under the gang statutes are eligible, terrorism-related offenses, and, Mr. President, finally, drug kingpin offenses, because I cannot find the exclusions in the site the senator previously described.
Senator has the floor.
Mr. President, about the terrorist, if someone kills people in a terrorist incident, they would be excluded from this. The crimes that are allowed in the earned sentence credit expansion are all people who will eventually be leaving prison because their terms are not life sentences. The intention and the purpose of this bill is to allow us to incentivize people to learn better behavior, to redeem themselves, and to rehabilitate themselves by making certain that they are behaving in accordance with all of the rules. They would be required to maintain, as long as they are in the prison, the best behavior possible. Secondly, they would have to participate fully in any drug and alcohol treatment, therapy, job training, and other things. These are proven proven and data-driven efforts to, these are proven and, excuse me, these are proven and data-driven efforts. Mr.
Sorry, if the senators could
I'm
clear the
gonna wait
way
for
so
just a second.
Senator can be seen. Yeah, if Senator could
Thank you.
clear the floor.
These are proven.
Thanks, Senator. Please proceed.
Yes, sir. These are proven and data-driven programs. 34 states around the nation have more generous earned sentence credits than Virginia does. And there have been studies that have shown, including those by the National State Conference of Legislators, NCSL, where they see that actually recidivism has been reduced. I urge the body to support this bill that has been vetted by the Crime Commission. There is a companion bill in the House that has already passed through, and I encourage my colleagues to vote for this bill. Thank you.
Thank the senator. Further question?
Mr. President, speak to the bill.
Senator has the floor.
Thank you, Mr. President. Mr. President, I think as we have these conversations, some of us have a different view of what compassion is and how the criminal justice system should work. Certainly, I myself feel that as you're looking at individuals who have committed nonviolent drug offenses, that is very worthy of our consideration for reduced sentences, particularly if they're doing the things to get their life in better order while they're incarcerated. And we've spent a lot of time over the last number of years trying to incentivize facilities to come up with programs and incentivize trying to get individuals out. But, Mr. President, when you're looking at some of these other offenses, just because you're doing good in the facility should not discount the type of offense that you've committed or the fact that a judge or jury has sentenced you to those particular levels. And, Mr. President, as we're looking at that, if we don't think the levels are right, we don't think that the possibilities or sentences are accurate, then we should change those. If you don't think that somebody should be able to get a certain number of years as a penalty for committing an offense, then we ought to change that. But don't say, judge and jury, you can hear the evidence, you can make a determination of a sentence, but we're going to discount that as long as they do okay in the Department of Corrections. So, Mr. President, I certainly understand what the senator has articulated about trying to give people a second chance. And that is a laudable goal. But some of us have a disagreement of when that second chance should come. And I certainly don't think, and I don't know that it's not an oversight, but things like being a drug kingpin or being convicted of a gang offense is one that even if you are doing well in prison, we should give you a break on the sentence that has been decided by a jury of your peers.
Mr. President.
What purpose, Senator from Eastern Fairfax? Senator Servell.
Thank you. This is Senator from Hanover. Yield for a question.
Will Senator yield?
Yes.
Senator yield. You have the floor.
Thank you, Mr. President. I would ask the senator, would he agree that today, under current law, if we do nothing today, that if somebody's convicted of a gang offense, a DUI third, a terrorism-related offense, or drug kingpin law, that they would be eligible to get up to a 15% sentence credit if they do all the things they're supposed to do in jail in contravention of the judge or the jury's sentence?
Senator has the floor.
Mr. President, I would answer the gentleman that yes, that 85% of the time of the sentence that was given by a judge or jury, you would have to do. So, Mr. President, if the gentleman is trying to make the point that he believes a different percentage of time you have to do is more equitable, that is certainly a valid point. 85% is the vast majority of the time, and there is a positive for giving some incentive. But I'd also answer the gentleman, Maryland, I think, is one of the states that the senator from Northern Virginia quoted as a state that gives a lot of credit for what you do positively in the Department of Corrections. And Maryland's violent crime rate is significantly worse than Virginia's. Over double. I think Maryland, on the latest list, had the fourth highest violent crime rate compared to Virginia, which was 44. So I currently like the status we're in now, than what some other states are in that have similar policies.
Gentleman, you have one more question?
Senator Yield?
Yes.
Senator Yield, you have the floor.
Okay, Mr. President, so I think just to interpret the senator's views correctly then, the senator does not have an issue changing the jury's sentence by up to 50%, but that he would think that changing it by more than that for certain people who pose the least amount of risk would be some kind of problem?
Senator has the floor.
Mr. Chairman, I would disagree that my sentiment is that somebody who's been convicted of a gang-related offense, a terrorism offense, a drug kingpin offense, poses the least amount of risk in the system. So if we were talking about non-violent drug possession offenses, gentlemen and I could have some agreements on those, and we could come up with some substantive agreements. But when you're talking about unlawful wounding and the other offenses I related, we have a disagreement of whether that should be. Malicious wounding is exemption, unlawful wounding is not, as I see the gentleman referring back to his code section.
Further question?
No, I thank the gentleman.
Thank the senator. For what purpose does Senator from King George, Senator Stewart, rise?
Speak to the bill, Mr. President.
Senator has the floor.
Thank you, Mr. President. And Mr. President, I'd like to thank the gentlelady who sponsored this bill for spending quite a bit of time with me before session today to go through all this, because it is an important topic. And let me preface that by saying again, I've practiced law for 30 years and I've defended an awful lot of people in those years. And for a short period of time, I was a prosecutor. And I was misguided in that, and I had to give that up and go back to defending people because that was the right side of the fence to be on. And I've had clients that were involved in drugs and that I defended for those offenses, and I've had those clients look me in the eye and say, I would do anything for those drugs. Nothing can stop me from going after those drugs. I'm that addicted. And I've had clients who've gone to jail for a little while and said that was the only thing that dried me out and got my life back on track. And I believe in what the senator is doing here. And I want to preface my statements by saying that. There are certain offenses where we need to give incentive to help people get their lives in order so that they can come back out and be a happy, thriving, productive citizen like everybody tries to be, and not a risk to the community. When I look at this bill, and I support that, I support the intent of this bill, but it's just like the last one, where we let a 40-year-old pedophile out to go back and molest children again, and that's not what we're here for. This bill does the same thing. In fact, this bill lets the 40-year-old pedophile out again. The very same language as before. And I've spoken with the gentlelady about this bill, and I do believe that she's been able to, I think yesterday, in Senate Finance, as late as yesterday, they were able to remove a lot of these child pornography charges, like manufacturing, financing, and selling child pornography, use of communication system to solicit it, displays of grooming videos. I mean, this stuff is sick. It's sick stuff by really sick people. And that was in this bill as of yesterday, and we think we got it all out. We think we got it all out. I can't see, and I've read the bill, I've read the amendment from the Senate Finance Committee. I still believe that felonious prostitution with a minor is in the bill, and aiding prostitution with a minor is still in the bill, and I apologize if I'm wrong, but it's not excluded. There are very few exclusions, in fact, in this finance substitute. This bill allows domestic abusers the same opportunity, and I've prosecuted those people, and I got to tell you, that's a hard thing to do because you'd get and typically it's a man. I don't mean to be biased towards anybody, but typically it's always a man, and they beat the devil out of their wife, and their wife calls the police to stop it, and the police arrest him, and they put him in jail, and then the wife would come to me as the prosecutor, and you try to comfort him, you try to console him, you try to everything you can to get him through it. and you think they're okay and they're going to hold up and they're going to be a witness. And you get a call about 3 days later, Richard, I can't testify because he'll beat me again. And I want to drop the case. And I would say, I'm sorry, whether you testify or not, I'm trying the case. And you tell him it's me and not you. And if he wants to beat me up, tell him to come try. And every time it was the same thing. They were afraid to testify. And you talk about a felony violation of a family abuse protective order, which this bill allows them to get 15% off their sentence. Doesn't sound like a lot, but it is. These people get the benefit of that. They come right back out and beat them again or kill them. The case that we had in Northern Virginia some time ago where the guy beat and raped the woman, went to court, they let him out on bail. We've talked about it in this session. It was right before it happened. Got out on bail, went right back and killed the woman. These are not people we need to be letting out or giving incentive. There are some people that, I hate to say it, you can't rehabilitate them. There is an evil in them. There's just nothing you can do with them. And we have to keep people safe from those people. I've seen them. I've dealt with them. This bill does not do that. It doesn't keep people safe. It goes on. Third offense, strangulation. That's a pretty serious offense when you try to kill somebody by strangling them. It gives them the benefit of the sentence credits. Stalking, third offense stalking. That's another pretty serious crime. It allows them to earn good sentence credits. And then you talk about all of the things that we have been discussing lately. People who could take advantage of this still under this bill, those that would burn a cross to intimidate people. Another pretty sick individual that does stuff like that, we're going to let them take advantage of this bill so they can get out early. Placing swastikas to intimidate. Displaying nooses to intimidate people. Why do we want to give them a chance to get out of jail early? That makes no sense to me, and I don't know why people would even vote for that sort of thing. Solicitation to commit murder. Have you ever been the subject of someone trying to get somebody to kill you? It's a pretty bad feeling. Anybody who's been through it. It's a pretty bad feeling. Burglary and all of the burglary offenses. Anybody that breaks into your home in the middle of the night, and that's what burglary is. Burglary is not stealing something from a table. It's breaking into your home in the middle of the night while you're in bed. We're going to let those folks take credit of this. Felonious crimes against nature. Again, these are sick people. And the gentleman from Hanover covered a lot of these other offenses. And, Mr. President, I want to say I'm not opposed to this bill. I support the bill. I think giving incentive to get people back on track and get their lives in order is a good thing. It is what I have worked my entire life at doing with people, in representing these folks and trying to help them. But what is concerning me and what I object to, and I hope you all will just listen, we've got to get these offenses out. We've got to make sure we've excluded the bad offenders, the sick people, the perverts, the pedophiles, the molesters, the abusers. These types of people don't need to get the benefit of this because, frankly, you're not going to help them by letting them out early. You're going to injure the people that we're all trying to protect. I think we need to continue to work on this bill and modify it, and it could be a really good piece of legislation that could serve as an incentive and a model to try to help our offending population for offenses that can be rehabilitated and be of service to the entire state. But the bill is not there yet.
Thank the Senator. For what purpose does the Senator from Rockingham, Senator Obenshain, rise?
Mr. President, speak to the bill.
Senator has the floor.
First, I want to apologize to the gentlelady from northeastern Fairfax. I think I probably told her that I wasn't going to stand up and say anything about this, but I do want to make two quick points that I think need to be made. Number one, to Senator from King George's point, I looked at the fiscal impact statement on this, and this bill will, I guess, save money, except to the extent that we're going to be putting people back on the street who are going to be committing crimes in communities. And if I read this accurately, and perhaps the gentlelady from northwestern Fairfax might address this in her closing, but it looks like there are 2,800 inmates who are going to be eligible for release under this in the first year, and maybe 6,100 inmates who are going to be eligible to collect these credits. And to Senator from King George's point, it would be awfully helpful if we could see how that broke down. I'm sure that the Department of Corrections could tell us how many of those 2,800 people who are going to be eligible in year one have been convicted of which crimes. So we see how many hundreds of offenders in categories that every single one of us would object to turning out into our communities would be included in that. That would be especially helpful. The second point that I want to make is that we just addressed Senate Bill 5018 from the gentleman from Loudoun County, and I join those who commend the gentleman from Loudoun County in trying to make that a better bill, and he did make it a better bill than I think it initially was. There was language added in that precluded persons from being granted compassionate relief in the event that they are serving a sentence imposed for a conviction of either first or second degree murder. I would point out that this bill includes that bill. In lines 11 through 19, it includes section 53.1 40-1 dealing with conditional release, dealing with compassionate release. It does not include that limitation concerning first and second degree murder. So if we pass this bill in this form and it goes to the other body, I can guarantee you which version is going to come back. And it ain't going to be the one that we just addressed from the gentleman from Loudoun County. And I suspect this was an oversight, and maybe we would be well advised to go back and add that language to make this a little less objectionable to some. But if the gentleman from Loudoun felt strongly enough about this to have added that, I really submit that we just passed legislation that expressed the intent of the Senate not to provide for that type of conditional compassionate release for terminally ill inmates who've been convicted of first and second degree murder. This is completely the opposite direction. It does the opposite. It does provide for the conditional release of those inmates, and I would respectfully submit that that inconsistency alone is a good reason we ought to take a serious second look at this piece of legislation, and maybe it would be a good idea to slow it down and address that if that is a concern of the gentlelady from northwestern Fairfax. So I will not support this bill primarily because of that and the provisions within the remainder of the bill.
Thank the senator. For what purpose is the junior senator from Richmond City, Senator Morrissey, rise?
Speak to the
Senator's the
Speak
floor.
to the measure, Mr. President.
Senator's the floor.
Mr. President, I hope the body will support what I call SB 5034, an incentive bill. And it's funny because the other day a very good friend of mine, former minority leader in the House, Ward Armstrong, called me and he asked me about how I felt about the Senate, and I said that I really like the discourse that goes on between both sides. And I listened carefully to the senator from King George, and he talked about all the things that he didn't like in the bill, and I understand that. What's interesting is the perspective that I saw from this bill, and I know that the senator from northwestern Fairfax County has tried to accommodate everybody, and I applaud her for this, but this bill excluded what was described as felonies, violent felonies. And I counted 119 exclusions in this bill. Just went through it one after the other. And these are the bills that a person would not get earned sentence credits for. These are just some of them. It's kind of the opposite side of the senator from King George's comments. Number one, involuntary manslaughter. And that, of course, is that every lawyer in here knows is the accidental killing during the commission of a lawful act. The 70-year-old lady who's got a perfect driving record but kills somebody coming home from church. Involuntary manslaughter. Not eligible for earned sentence credits. Mob-related activity. Well, I'm sure most folks remember the star basketball player from the Peninsula, Allen Iverson. Went to Georgetown, played for the Sixers, is in the NBA Hall of Fame. He went to jail for a mob-related crime until he was pardoned by the governor and he went to Georgetown. That would not be an individual who would be able to earn sentence credits. I think the gentleman from King George referred to prostitution. Not eligible. Don't consider that a violent crime. You're not eligible for earned sentence credits if you marry somebody who you're not eligible to marry. Bigamy. You're married at 20, you go to Vegas and you get married and you don't see the person the next week for the next 20 years. You think, what happened to them? Maybe it's divorce, whatever. You marry again at 40. Well, that person is still living. You're charged with bigamy. You're not eligible for earned sentence credits. The list goes on about, and I guess the point is, the gentle lady from northwestern Fairfax County did her best, considering all of her colleagues, to fashion a bill, and that's what we have before us. But at the end of the day, it's the following. It's an incentive bill. I would tell my friend from King George, it's an incentive bill to incentivize people to do well whilst they're in prison. Take advantage of a drug program. Get your GED. Go to Orbit. Learn a trade. Be certified in drywall or painting. Incentivize them to do that rather than perhaps engage in mischief. And you know who understands this bill more than anybody, and it has been using it for decades? Insurance companies. They understand that the need to incentivize drivers to do well. They don't want to pay money for accidents, and they realize that if they incentivize somebody to drive well, there won't be an accident and there won't be a payout. So they created, the insurance companies were the folks who created this demerit system. And if you notice, as every year goes on and you're a good driver, your demerit points fall off, including reckless driving, which is actually a Class 1 misdemeanor. And they do that because they know, the insurance companies realize that people want to get to that 5+ point level. And if they do that, they're going to drive more carefully. And so that's what this bill is, incentivizing prisoners to do well. And then I know I'm trespassing on the body's time, but I just want to share a little vignette with you. I think it was a gentleman from Hanover that talked, I believe it was him, about not giving these people second chances. And this is tied in with driving offenses, but I remember, I don't know how many folks from Fairfax County remember, there used to be an area called Tyson's 2. They now have a big shopping center up there, but it was dirt, mounds of dirt. And we used to, as teenagers, ride our dirt bikes through there all the time. It was great fun. And the police would come up around the sides, and they would use their bullhorns, and they'd tell us to get out of the private property. And sometimes we did, sometimes we didn't. We were having too much fun pretending that we were Steve McQueen, driving over, doing wheelies, going over these hills. And then the police got smart, Mr. President. And you know what they did? They sent in the Fairfax County Police on motorcycles to get us off of Tyson's 2 private property. Well, that just emboldened us. I mean, to now have the Fairfax County Police chasing us on motorcycles through acres of Tyson's 2, that was just the gold standard. But if I were to have been caught, and I never was, and I hope Senator Servo can tell me there's a statute of limitations on that, I wouldn't have a driver's license until I was 90. But we want to give people second chances, Mr. President. This bill not only incentivizes people to do well when they're incarcerated, but it gives them what? A second chance. I don't think the bill goes far enough. Many of these 119 crimes shouldn't be in there, but it's the best that we've been able to do, and it's because of compromise. So I hope the body will support it.
Thank the senator. For what purpose does Senator from Arlington, Senator Favola, rise?
Thank you, Mr. President. I rise to speak in favor of the bill.
Senator has the floor.
Thank you, Mr. President. This, too, was a bill we heard in Rehab and Social Services, and I just want to provide some information the body might find helpful as they're deliberating on this bill. There was a report done by the Crime and Justice Institute and the National Institute of Corrections in 2007. And these two institutes actually did a comprehensive review of credit sentencing programs across the country. And what they found is states that don't offer credit sentencing are completely missing an opportunity to reduce recidivism, to respond to evidence, and to enable offenders when they are released, and these offenders will be released, to actually reintegrate into society and therefore reduce recidivism. This bill is really about encouraging personal responsibility. What it does is it rewards behavior, it presents a carrot, which psychologists were telling us is far more effective than the hard punishment approach. The carrot is the more effective approach. And we're encouraging individuals to actually take responsibility for their future behavior. And that's where we have to go. If you believe in restorative justice, or that individuals can in fact be rehabilitated, then this is a tool we need to use. I know there's a lot of debate about which crimes should be included in the sentence crediting bill before us, but this is not a big leap from our current statute. And I think it's something that we need to try. There have been a lot of cooks in this recipe here before us, but we need to move forward. I expect we'll be back. This bill may be tweaked in the future, but I really think it's worthy of our vote. Thank you, Mr. President.
Thank the senator. For what purpose does the senator from Western Fairfax, Senator Marsden, rise?
Thank you, Mr. President. Speak quickly to the bill.
Thank the senator. You have the floor.
Thank you, Mr. President. If it's a small measure of comfort with regards to any sexually based offense, you could earn your way out of Department of Corrections a little bit early, but you're also putting yourself up for an early commitment, civil commitment of an indeterminate period of time to the under our civil commitment laws. So there is a backstop here that could work to our benefit. Thank you, Mr. President.
Thank the senator. Do any senators other than the patron wish to be heard regarding Senate Bill 5034? Seeing none, Senator from Northwestern Fairfax, Senator Boysko.
Thank you, Mr. President. We have had a vigorous and extended discussion and deliberation about this bill over the past 4 months, and I appreciate all of my colleagues on both sides of the aisle for for participating in that and trying to make this better and more palatable to the majority of members in the body. I especially want to thank the senator from Bedford who brought it to my attention that we left out some serious issues surrounding rape and crimes against children, and also for the very thoughtful discussion with the senator from King George today. Let's just talk about this, though. You know, it seems like we have two conflicts in our hands, right? We want safer communities for everybody. Everybody in this room does. Every person in Virginia wants that. But we also are a nation and a community that believes in personal responsibility and redemption. And this concept, earned sentence credit, enables that. You know, I really want us to think back about why we're here and having this conversation in the beginning. When George Floyd was killed and Breonna Taylor was killed, it brought up the whole issue around the racial injustice and criminal justice reform. And it's not one silver bullet that's going to solve all of those problems. We know that. And so the people on my side of the aisle got together and we put together a package of comprehensive pieces of legislation that would address different components in our criminal justice system, and we included prison reform in that because we know that the United States is at the very top in industrialized nations that imprisons people. And here in Virginia, we are above that national average. In fact, 779 individuals per 100,000 Virginians are incarcerated. And there are clear evidences of substantial racial disparities. And we're spending more than $1 billion a year to keep people in prison. And that leads me to the question is, why are there racial disparities in our prisons? And do we wonder how we got that place where we have people who are, you know, our prisons are overcrowded. We know that the majority of them are people of color, even though there are only 19% African Americans in Virginia. In the 1990s, we passed a lot of tough on crime bills, and that was before I was here. And they were not necessarily enforced fairly. And prosecutors in many areas historically chose to charge young men of color, black and brown men, with higher numbers and more extreme charges for the same violent incidents that white men have also committed. And often, this has involved charges stacking and the loose use of malicious wounding charges, among other things. And I will point out that malicious wounding charged individuals are not eligible for earned sentence credits in this, and I appreciate what my colleague, the junior senator from Richmond, said earlier today, that we're not including enough people, but this is a step in the right direction. Many of the people who are incarcerated right now, who are in prison, are serving 40, 60, or 80 years more for terrible mistakes that they made when they were young, 18, 19, 20, 21. We know that there is data that the brain is not fully functioning until you're about 26. And I bet a lot of us in this room did some really bad stuff when we were that age. And we're fortunate enough that we're all free in this room, right? But there are some people who did heinous, awful things, and now they are in their 60s and 70s, and they have repented, they have redeemed themselves, and they would like to have a chance to go back to their families. You know, opponents, I've heard in this room today that it's going to go easy on some people who are going to endanger the public, but that's not what the evidence shows. States with strong earned sentence credit programs have seen reduced recidivism in all types of individuals, regardless of the types of sentences that they're now serving. And research has showed actually that it's prolonged confinement that further damages inmates, and it's counterproductive to the mission of rehabilitation and a path to self-sufficiency once that individual re-enters the community. The factors that drive violent crime are shame, isolation, low socioeconomic status, and continued exposure to violence. We've already said it, 34 states offer higher earned sentence credits than Virginia, including conservative states like my two home states, Alabama and Arkansas, but also Texas and Oklahoma. And we've seen other states revamping their prison systems, not only because they see reduced recidivism and working towards restored justice, social justice makes sense, but also because they have seen significant cost savings. The reason that I'm here standing for this is because I believe that people deserve second chances. I believe that expand earned sentence credits provide an incentive to work hard, to build job skills, to treat substance abuse, and to seek an education. We can release inmates, and all of the people who are going to be eligible for this are going to be getting out. They will be released at some point. We can either release them after living with no opportunities, who are bitter, they lack skills, and they still feel hopeless when they get out, or we can do the right thing and treat them like human beings, giving them the opportunity to make things right for themselves and for their families and for the people in the community when they go back. Let's remember why we're here. We're here to fix our criminal justice system, and I hope every person in this room will stand with me and to vote yes on SB 5034, and I thank you very much.
Thank the senator. For what purpose is the senator from Franklin County? Senator Stanley.
Thank you,
rise.
Mr. President. Briefly, if I may speak to the bill.
Senator has the floor.
Mr. President, and I don't mean to tread on the patron's time in speaking last, but I had to stand up and just remind the body, as I reminded myself, that so many times for so many years we've stood in the chamber and we've had the senior senator from Fairfax, when he's not coming up and telling you some really hilarious joke, stand on the floor and turn to us and say, when we talk about criminal reforms and how we are in Virginia, that Virginia possesses the lowest recidivism rate in the nation. How many times have you heard the senior senator from Fairfax say that Virginia has the lowest recidivism rate in the nation? We do. And why is it? Because the system we have in place is pretty good. And I've heard about now these 36 states that have all these great programs for all this stuff. Well, guess what? Common sense dictates that they all have higher recidivism rates than the Commonwealth of Virginia. More violent crime. What does that tell you? It tells you where they got these programs. They're not working. It's not doing so well. So, ladies and gentlemen, when we think about these things, I'll tell you something, and I know we've heard senators here who are attorneys. I'm a practicing attorney. If you haven't figured that out yet, I have thousands and thousands of clients, many who have done prison times. And when they come out, they're either going to commit a crime or they're not. They either get it or they don't. So many times, how many times have all of us who practice criminal offense law sit there on a probation violation, major probation violation report? We look at our clients, we talk to them, we lecture them, we tell them, stop. If they're going to do it, they're going to do it until they get it. And there's not a program in the world you can put them through, not a drug program in the world you can put them through, not an education program that you can put them through that's going to change their mind until they change their minds themselves. We kind of have a Pollyannish kind of view on our prison population. Let me tell you, of all the thousands of people that I've represented in 26 years, I can tell you, fear of what they're going to do to you drives them not to do the crime. Knowing that it's going to be a tough penalty if I do this, they actually think about it. And they say, well, I'm not doing that. But they're not going to change their hearts and minds. We can't change their hearts and minds unless they're willing for those hearts and minds, their own hearts and minds, to be changed. Because as the senior senator from Fairfax says, the Commonwealth of Virginia has the lowest recidivism rate in the nation. We don't need to change what we're doing because it's obviously working. Thank you, Mr. President.
Thank the senator. For what purpose is the senior senator from Fairfax? Senator Saslaw rise.
Right now, we have the lowest recidivism rate in America, and I'm a gambler, and I'd be willing to bet that after this bill fully kicks in, we're still going to have the lowest recidivism rate in America. Let me explain why. Right now, if you get a 20-year sentence, you've got to serve, before you're even eligible for parole, you got to serve at least 17 years, okay? 85%. Maybe a little more if you're from Franklin, all right? But after this bill kicks in, that 17 drops probably to somewhere between 14 and 15 years. I guarantee you that's not going to turn us into Dodge City, okay? You can bank on that. You know, Virginia's not going to become the OK Corral. They're still going to have to pull an enormous amount of time, but it does give them an incentive, okay, to behave. So this is something we ought to take a look at. You know, it's cost us a ton of money to keep these people there, and particularly, you know, with your nonviolent people, you know, I'm sure you can, if you dig, you can probably find some that may be potentially violent. But if they're nonviolent and we're paying $35,000 to $40,000, $50,000 a year to keep them there, quite frankly, if they're nonviolent, and that's virtually what this bill applies to, hell, it'd be cheaper to send them to UVA. So, you know, we might, you know, just from a financial standpoint, might take a look at that. But this is not going to turn us into some lawless state. And if I thought it was for a minute, I wouldn't vote for it. But that's not the case. And there's no reason why we can't support this bill.
Mr. President. Senator from Franklin County, Senator Stanley.
Will the senior senator from Fairfax yield for a question?
Will Senator yield?
I yield.
Senator yields.
Thank you, Mr. President. I'd ask the gentleman, my friend, I'd say, after listening to his speech, is the senator basically saying that Virginia has the best criminals and better criminals than any other state in the nation?
Senator has the floor.
Depends on where they come from.
Thank you, Mr. President.
Thank the senator. What purpose is Senator from James City County? Senator Norman rise.
Thank you, Mr. President, to speak to the bill.
Senator has the floor.
First of all, I will take that bet with the senior senator from Fairfax County. And when I win, the unfortunate thing is because it's going to take some time to collect the demographical information, neither one of us will be around. And that's what we are doing, is we're making a policy decision where the empirical data is not going to be available for some period of time. So I will take that bet. I further will say to the senator from northwestern Fairfax County, I make no apologies that I cannot stand with you on this bill. I have no misgivings about what the ultimate outcome in the vote is going to be, but we get confused. Hey, I don't do anything for $20. That won't even pay for 1 minute of my law time.
I tried.
You did. And you can't bribe me into voting for this bill, sir. I would say I can't stand with you. I think we do get confused, and this is not a bill that is driven by a partisan divide. It is a bill that is significantly driven by a policy divide, and they are very distinctive. And unfortunately, on both sides of this aisle, I've seen too many of these criminal justice reform bills coming through on a partisan basis, more so than on an intellectually honest policy debate. The senator from Franklin County reminded us all about the recidivism rate. And I will suggest to you, Mr. President, this. I may not be as cerebral as some in this body, but I am absolutely capable and have read a number of academicians' reports dealing with recidivism and compassionate release. What is curious to me is that some, with one major exception of a member of this body, this initiative and some others are being driven by individuals who, from an academic perspective, have read reports but know nothing about these people in actual life. And what I say to you, Mr. President, as you look out over the senators, there's between 25 and 30% of the members of this Senate body who have dealt with these individuals on a personal and professional basis. And that is a very different situation, Mr. President, is that we are not looking at an academic explanation. We are looking at experiences of life.
Thank the senator. Question is, shall Senate Bill 5034 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 16.
Ayes 21, noes 16. Senate Bill 5034 passes.
Senate Bill 5038. A bill relating to response to mental health crisis, establishment of the mental health awareness response and community understanding services Marcus alert system.
Senator from Prince William County, Senator McPike.
Thank you, Mr. President. I move the bill pass. And speaking to the motion.
Senator, has the floor.
Thank you, Mr. President. As the clerk aptly stated, this is the Marcus alert bill. And there's part of the debate today, I think, lends itself to what is now contained within the substitute that's before you. We've collaborated with DCGS, behavioral health, and other stakeholders in the process to get to this substitute. This fits nicely within actually helping to make sure that those that are suffering from different mental health, developmental disabilities, or other crises have the resources available to them before they get into the criminal justice system. Not only that, but creating a safer context of having a professional both on-site as well as having and developed our call crisis center across Virginia. So there's sort of two folds that the bill addresses. One is the call crisis framework. The second of which is developing the appropriate protocols for where we have mental health professionals respond into our communities, as well as how they're supported by law enforcement. So if you've talked to law enforcement officers, and I know we have one that was a former law enforcement here in this body as well, is they want the resources, they want the professional help, and the expertise. That's what this bill begins to connect our dots in the framework that this body has done a lot of work on STEP Virginia. And so this is really fitting in nicely with the framework that we've started to invest in same-day assessments. Now it responds to mental health providers within our communities. So this is a critical component. It also requires localities to create and allow for a voluntary database for those who wish to identify themselves or a family member having a different mental health or developmental disability. That way there's additional information for the 911 call takers and first responders. There's many examples, whether it be a kid with autism or different things. Unfortunately, we saw one fatal shooting across the nation just last week involving a special needs kid. And so the more information we have to the first respond network, as well as providing the appropriate level of trained staff, is critical to both saving lives as well as diverting people from our court system, Mr. President, and I hope the bill passes.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5038? Seeing none, the question is, shall Senate Bill 5038 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 15.
Ayes 21, Noes 15. Senate Bill 5038 passes.
Senate Bill 5118, a bill to require certain utilities to develop an emergency debt repayment plan.
The senior senator from Richmond City, Senator McClellan.
Thank you, Mr. President. I move that the bill pass. I'm speaking to the bill.
Senator, you have the floor.
Thank you, Mr. President. As you know, the State Corporation Commission put in place a moratorium on disconnecting utilities, gas, water, and electric for non-payment during the COVID crisis, and that has been extended to October 5th. They also put in place an order requiring those utilities to offer an extended payment plan for up to 12 months and to report certain data to the Commission so that they could figure out the scope, the size of the uncollectibles, and the cost that those utilities incur to put that payment plan in place. But that requirement expires with the moratorium on October 5th. What this bill does is essentially codify what the State Corporation Commission did. Also says that if in the hopefully unlikely event we are ever in a similar state of emergency, and if there is a moratorium, that a similar payment plan would have to be offered in the future. The only other thing it does, this applies to those utilities that are regulated by the State Corporation Commission. It does provide that upon request from the relevant chairs of the relevant committees, that any local government utility would have to provide that information on any uncollectibles that they have, so we can determine if we need to deal with the debt they're incurring. And then it provides that utilities may seek cost recovery from the Commission of prudently incurred costs. With that explanation, I move that the bill pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5118? For what purpose does Senator from Fairfax City, Senator Peterson, rise?
Mr. President, speak to the bill.
Senators, the floor.
Mr. President, ladies and gentlemen of the Senate, I appreciate the work that Senator McClellan, or the senior senator from Richmond, has done on this bill. And I think she's correct that this is a compromise that reflects what's going on with the State Corporation Commission. And I do intend to vote for it. But let me point out two factors which I think have been getting swept under the rug a little bit in the reporting on this bill. One, most of the players, I think, or perhaps all of the players, are in agreement with this bill. That's the utilities, the co-ops, municipally owned utilities, the consumer groups, everybody else, Red Cross, whoever else is interested. And the reason is simple, because the cost of this program will be shifted onto the rate base. In other words, ordinary people that pay the bill every month will pay a higher price based upon the fact that we're going to swallow $200 million or whatever the outstanding amounts are that will be wrapped up in this program. That's number one. Number two, I'm constantly hearing, both in this bill and in the evictions moratorium, that if we lift this policy, if we lift the moratorium, there will then be a flood tide of disconnections and evictions and whatever other prohibited activity is out there. Let me point out something obvious. When you forbid an activity for 6 months and then lift that prohibition, it doesn't matter what the economic circumstances are, there's going to be a flood tide of that activity suddenly happening in the next few weeks. I've practiced landlord-tenant law for 26 years. I'm probably the only person on the floor of this body that actually have represented clients in front of FERC. I very well understand this industry. They're going to get their money back, okay? Have no doubts about that. They're going to figure it out. What worries me is that we are creating precedent after precedent where we essentially suspend the rules of economics in what we call an emergency. But the question is, when is the emergency going to be over? That's my question, because we've had an emergency now for 6 months. We could potentially have another emergency for another 6 months. And my problem is that if I look at the stock market, it's over 28,000 right now. If I look at consumer spending, it's stronger in August than it was in July. It was stronger in July than it was in June. In a lot of ways, people have more money on hand than they did 6 months ago. That's not to say everybody. That's not to say some people have been impacted. It's not to say we don't have 8% unemployment. We do. But recognize that when you have the federal government put $3 trillion additional dollars into your economy, it's a little bit different than the Great Depression. We're not going through the Great Depression right now. And I'm worried that we've suspended the rules of economics based on, frankly, a situation that doesn't exist. And while we do have people that are stressed, while we do have people that are in trouble, the bottom line is at some point we have to get back to normal. We have to have accountability. We have to tell people if you don't pay your bill, eventually the service is going to get cut off. Now, this is a regulated industry, so it's slightly different than the landlord-tenant situation. And I have no doubt that in a regulated industry, it's appropriate sometime to ask that that industry pick up the slack. But if we come back here in January and people are still saying, oh, you can't have disconnections, so you still got to carry people to all these other things, I can tell you right now, this senator is going to be putting in legislation to limit the governor's powers, limit the SEC's powers, because at some point, we're going to have to be accountable for our own lives and our own decisions. So I do support this bill. I think the Senator McClellan is exactly correct that this codifies what the SEC has done. It codifies what the governor has proposed, but that must be a short-term proposal. You cannot live this way. You can't live this way. Eventually, we got to get back to people being accountable for their own decisions. Thank you.
What purpose does the Senator from Rockingham, Senator Obenshain, rise?
Mr. President, rise to speak to the bill.
Senator has the floor.
You know, I think when bills like this are introduced, people automatically think of our two large utilities serving Virginia. Fact of the matter is, in rural Virginia, we have some really very small rural utilities, some serving as few as 10 or 11,000 households. I don't know what A&N serves, but it's not a lot. Southside Electric Cooperative, they don't have the reserves and the rate base for this policy to continue indefinitely. To the point made by the senator from Fairfax City, this bill, and the patron just mentioned that there is a moratorium in place, and she's right, and it's been extended until I think sometime in October. But this bill doesn't just relate to the period that the moratorium is in place. It relates to the period of the moratorium or a state of emergency, So I have no idea how long this state of emergency or another state of emergency may last. And when you talk about shifting the burden to a rate base of 10,000 homes, it becomes a real problem for those ratepayers who are left holding the bag. And I would additionally point out that I don't question the motives of imposing a moratorium. I think that we did have and do have a lot of families and households that are really hurting. But remember, this is not a means-tested issue. Anybody can stop paying these bills, whether you can afford it or not. And this shifts that burden to those who continue to pay. And frankly, some of those who continue to pay are frankly some of those who are least able to pay, who just simply feel very strongly a sense of obligation to pay my fair share. And I just question how small, regional, regulated utilities can possibly continue to exist in a healthy, viable way under a plan like this that could potentially be indefinite in duration.
What purpose does the Senator from James City County, Senator Norman, rise?
Thank you, Mr. President. I rise to speak very briefly on the bill.
Senator has the floor.
First of all, I want to thunderously applaud the senator from Fairfax City because he interjected some common sense into this discussion, and frequently in pursuits of altruism on this body, we cast common sense aside because we are undertaking some initiatives that make us feel better. And they frequently can make us feel better in the short term, but not in the long term. And I compliment him on talking about the suspension of an economic theory, because this is really creating a fiction. And I don't know whether some view this as a compassionate situation, or they see it as an initial step in a transferring of economic wealth. But I suggest to you, just as the senator from Fairfax City mentioned, there is a day of reckoning coming. There is a day of reckoning coming, and these delinquencies that are going to occur between now and October the 4th are just going to grow larger and larger. And in fact, it is going to become more of a challenge for some of these individuals to make the payments. And it's one thing to talk about a regulated industry, because the SEC has some complicity, and I won't get into the editorial comments about the current situation at the SEC and perhaps recent resignations that have taken place. But they have agreed to extend the moratorium until October the 4th. But I can assure you, between a regulated industry and an unregulated industry that is not subject to the jurisdiction and purview of the SEC, they are going to want to move forward with some dispatch to try and recover those deferred losses that have been incurred. And that is going to inflict a disproportionate impact and discomfort on some of these people that have not paid.
Do any senators other than the patron wish to be heard regarding Senate Bill 5118? Seeing none, the senior senator from Richmond City, Senator McClellan.
Thank you, Mr. President. Speaking to the bill.
Senator has the floor.
I want to be very clear what this bill does and what it does not do. This bill does not impose now or ever a moratorium on utility disconnects. Doesn't do that. There was a moratorium put in place by the State Corporation Commission because we are in the worst economic crisis probably since the Great Depression. There are record numbers of people who are unemployed. The enhanced unemployment they received from the federal government expired. Some who have applied for unemployment were late to get it for a wide variety of reasons, if they got it at all. Gig workers didn't get unemployment. A lot of people were excluded from unemployment who cannot pay their utility bills. And do we want, are you going to second guess the State Corporation Commission, who decided we don't think it's a good idea to cut off water, electricity, or gas in the middle of a health pandemic? I'm not going to second guess that decision. We will have an opportunity as a body to decide whether we agree that that moratorium should be extended or not. This bill is not that bill. And those same people who for 6 months have not been able to pay their bills, and what I've been told, but I'll admit I don't have the data to prove it, which is why there's a data collection in here, what I've been told is there aren't people gaming the system. The people not paying their bills are not paying them because they can't. They will not be able to pay 6 months worth of bills up front all at once. And so what this does is give them and the utilities some certainty of how we will stretch out that debt, how we will deal with this situation if, God forbid, we're in it in the future, because this only applies to a moratorium imposed during a state of emergency, because nothing would prohibit the utilities from disconnecting absent a legally imposed moratorium. These utilities would be entitled to recover costs anyway. They would spread it, whatever they don't collect, over the rest of their rate base anyway. This is not a one-size-fits-all, how are you going to recover that cost? Or how are you going to deal with that debt? And all of the utilities were very involved in this bill to address the differences between co-ops, investor-owned utilities, and munis. We are in unprecedented times. We have heard that over and over and over and over again. This is a very narrow bill that says, here is how we are going to try to alleviate unprecedented debt in an unprecedented time when people are economically hurting during a health pandemic, so they don't lose electricity, water, and gas. And we're going to collect some data so we know how big is the uncollectibles. What are these costs that could be imposed on other ratepayers? How much is the uncollectible the utility might not get, so that we as a General Assembly, with that data, can figure out, should we do something or not? So this is a very narrow bill. We'll have plenty of time to debate the merits of a continued moratorium on another bill, not this one, and I ask that you pass this.
Thank the senator. Question is, shall Senate Bill 5118 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk, close the roll.
Ayes 22, noes 13, Rule 36-1.
Ayes 22, noes 13, Rule 36-1. Senate Bill 5118 passes.
Mr. President.
Senator from Eastern Fairfax, Senator Surville.
Thank you, Mr. President. Having voted on the prevailing side by which we passed Senate Bill 5038 on page 5, I'd ask that we reconsider that vote so I can make amends for not voting for my colleague who shares my western border.
Thank the senator. The question is, shall the vote by which Senate Bill 5038 pass be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 37, noes 0.
Ayes 37, noes 0. The motion is agreed to. Senator from Prince William County, Senator McPike.
Thank you, Mr. President. I move the bill pass once again. And just a brief addition, I hope that we get some more bipartisan support for this. This model is actually used in liberal bastions like Georgia, Maricopa County, Arizona, as well as Denver. There's many other models, but this is actually modeled after some pretty good evidence-based programs, and I appreciate a little bit more bipartisan support. Thank you, Mr. President.
Thank you, Senator.
Mr. President.
Senator from King George, Senator Stewart.
Would the gentleman yield for a question?
Will the senator yield?
I apologize to the gentleman from
Senator
Prince William.
Senator yields. You have the floor.
I supported the original bill, but is this now a mandatory system?
No.
Senator has the floor.
So the portions, Mr. President, I answer the gentleman, are state-funded already as a part of the Virginia STEP program for the Call Crisis Center. It is still a local option in terms of how the systems are set up. Some localities already have them. Some of them have them in conjunction with the STEP Virginia CSB program that we have funded and support in coordination with localities. And so what I anticipate in the next couple of years is these programs will begin to grow as the protocols are set out within this bill in timeframes in 2022 and beyond. Thank you, Mr. President.
Thank you, Mr. President.
Thank the senator. For what purpose, Senator from James City County, Senator Norman rise.
Thank you, Mr. President. Very briefly, I would just say to the senator from Prince William County that interstate highway on bipartisan support runs in both directions.
For what purpose, Senator from Prince William County, Senator McPike rise.
Just to close out, I hope the bill passes. And again, mental health is not a Republican or a Democrat issue, Mr. President. Thank you.
Thank the senator. The question is, shall Senate Bill 5038 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 25, noes 12.
Ayes 25, noes 12. Senate Bill 5038 passes.
Mr. President.
For what purpose, Senator from Eastern Fairfax? Senator Serbell, rise.
Sorry, I guess I'm the trash man today, but having voted on the prevailing side by which we passed Senate Bill 5118, can we move to reconsider that vote so somebody else can get their vote cast? Not me. I didn't do it.
They just need 1 minute. Reset the system. Question is, shall the vote by which Senate Bill 5118 passed be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 35, noes 2.
Ayes 35, noes 2. The motion is agreed to. The senior senator from Richmond City, Senator McClellan.
Thank you, Mr. President. For all the reasons previously discussed, I move the bill pass.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5118? Seeing none, the question is, shall Senate Bill 5118 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 24, noes 12.
Ayes 24, noes 12.
Rule 36-1,
Rule 36-1. Senate Bill 5118 passes.
Memorial resolutions. Senate Resolution 540, celebrating the life of Lori Lee Brickley.
Senator from Prince William County, Senator McPike.
Mr. President, I move that the memorial resolution be agreed to.
Thank the senator. The resolution will be agreed to in the usual manner. All those in favor of agreeing to the memorial resolution will please rise. Yes, without objection, Senate will stand in brief recess.
Returning to memorial resolutions, if everyone would please take your seats. Sorry, Mr. President. Senate Resolution 540, celebrating the life of Lori Lee Brickley.
The senator from Prince William County, Senator McPike.
Mr. President, I renew my motion that the resolution be agreed to.
Thank the senator. The resolution will be agreed to in the usual manner. All those in favor of agreeing to the memorial resolution will please rise. The resolution is agreed to.
Senate Resolution 543, celebrating the life of Jacqueline Kidd King.
Senator from Roanoke County, Senator Suderline.
Mr. President, I'd move that the Senate agree to Senate Resolution 543 celebrating the life of Wytheville's Vice Mayor King.
Thank the Senator. The resolution will be agreed to in the usual manner. All those in favor of agreeing to the memorial resolution will please rise. The resolution is agreed to.
Commending resolution. Senate Resolution 542, commending Lieutenant Colonel Alexander Sinyan Vinman, United States Army, retired.
Senator from Prince William County, Senator McPike.
Thank you, Mr. President. Can that go by for the day?
Without objection, Senate Resolution 542 will go by for the day. The senior senator from Fairfax, Senator Saslaw.
Mr. President, I'd inquire of the clerk, does that complete the calendar?
Yes, sir.
All right.
Thank you, Madam Clerk. Is there any other business to come before the Senate?
Mr. President.
We're going to do announcements.
Senator from Hanover, Senator McDougal.
Thank you, Mr. President. Mr. President, can the journal reflect the senator from Fauquier as a way of pressing personal business?
Thank the Senator. The journal will so reflect. For purposes, Senator from Lynchburg, Senator Peake rise.
Yes, sir. Thank you, Mr. President, for two purposes. First, Madam Clerk, an inquiry. Are you sure you delivered this pink sheet to the senior senator from Fairfax on protocols of the Senate chamber? And then second,
He got 6 copies.
okay, well, somebody read it to him, please. And second, I rise for a point of personal privilege, Mr. President.
Senator has the floor.
And very briefly, I just want to bring this body's attention to the fact that a federal judge on Monday in Pennsylvania.
Would ask that, sorry, Senator, to interrupt. Would ask everyone to please take their seats for the point of personal privilege. Thank you. Please continue, Senator.
Yes, thank you. A federal judge on Monday ruled that the coronavirus restrictions imposed by the Pennsylvania governor were unconstitutional. The district judge said that the governor's attempt to stop the virus spread were undertaken with the good intention of addressing a public health emergency. But even in an emergency, the authority of government is not unfettered. The Constitution cannot accept the concept of a new normal where the basic liberties of the people can be subordinated to open-ended emergency mitigation measures. I just want to point that out to the body, and the senator from Fairfax City Peterson, when he talked about one of the bills, kind of mentioned that. And I bring this up to the body not to disparage the governor at all or the attempts that he has made, but to remind the body that we have the responsibility to uphold the Constitution and to maintain the separation of powers. And so I know that it's done for this session. There's going to be a federal court case. There's now a disparity in the federal courts. It will likely go to the Supreme Court. But this is not an attack on the governor. This is supporting our constitutional obligation. And so I'd ask that you consider that. And when we come back in January, I hope the body will have a different attitude towards maintaining our authority. Thank you.
Thank the Senator. For what purpose is Senator from Prince William County, Senator McPike rise.
Thank you, Mr. President. Rise for point of personal privilege and a motion.
Senator has the floor.
Thank you, Mr. President. I just wanted to briefly speak to the memorial resolution for Lori Brickley, who's the wife of former delegate David Brickley, and make a motion that we adjourn in the memory of Lori Brickley, Mr. President. And speaking to that motion, often we see people that weave within our lives, and Lori was certainly one of those people to me and my family. Graduating from Woodbridge High School, which my wife and Mr. President's wife also did. She went on to serve in Bevel Middle School, ACTS, so many other nonprofits, the Boys and Girls Club. In fact, Dave and Lori met at the Dale City Civic Association and were married at roughly a year later. And Dale City Civic Association is just one of those organizations that help a community thrive and really thread through. And Lori was such a great part of that. And I think in her own right, not just supporting sort of what David Brickley's work did, but her own work in the community was tremendously appreciated. So I just wanted to take a moment to recognize and appreciate the body's passage of the memorial resolution today, celebrating the life of Lori Brickley, and appreciate the body's consideration for adjourning in her memory today, Mr. President. Thank you.
Thank the senator. For what purpose is the senator from James City County, Senator Norman, rise?
Thank you, Mr. President. I rise for an announcement and a very brief point of personal privilege.
Thank the senator. You have the floor.
Mr. President, the announcement is that immediately upon adjournment, if the members of the Senate Republican caucus would very briefly gather in the hallway behind me, I would be most appreciative. And we need to move forward with some dispatch because there is a Courts of Justice Committee meeting that is going to take place, and we certainly don't want to slow that train down. Point of personal privilege. I want to extend my thanks and appreciation for my good friends on the other side of the aisle. Approximately 9 years ago, we went through a redistricting process, and rather than whine and whimper, I expressed my appreciation because it gave me the opportunity to make a lot of new friends. And I took that opportunity to go out and make new friends. I also appreciated, while we've had some spirited discussions, particularly yesterday, where we heard about horrific, unjustifiable acts of violence by law enforcement against citizens, particularly those of minorities. We heard about Kenora, Wisconsin. We heard about St. Louis, Missouri. We heard about Minnesota. And we heard most recently about Los Angeles. One of the opportunities that I had out of the redistricting was that I picked up, as part of the district, I have the privilege of representing Suffolk, Virginia. And yesterday, while we heard about all these other states, they seemed geographically distant from what is going on in Virginia. In case any of you happened to miss the news this morning about what happened in Suffolk last night at 9:30, as a police cruiser was driving through downtown Suffolk on Broad Street, someone opened fire on that police cruiser and hit it 3 times. Blessedly, they did not hit the police officers. The only thing that I would say, Mr. President, is that sometimes when these acts of unbridled violence occur in places as far away as the West Coast, that there are those, even locally, who think, you know, I can get away with doing this, and I want to express my frustrations and my anger. And it's happened very, very closely in Suffolk, Virginia, and I just wanted to bring that to the attention of everyone.
Thank the senator. For what purpose does the junior senator from Virginia Beach, Senator Kiggins, rise?
Mr. President, I rise for a point of personal privilege.
Senator has the floor.
Thank you, Mr. President. Yesterday, I had wanted to speak and just to follow up with the senator from James City County, but yesterday I felt like it was maybe not appropriate to speak after the senator from Franklin spoke. I was in awe of everything he had to say, so I chose not to speak yesterday, but would just like to follow it up. I know we've got a 2 o'clock meeting with the senator from Augusta, with his stand-up comedy with the Speaker of the House that we are all looking forward to, so I won't take up much time, but I know there's an issue, the issue of our police reform, and it's not going away. I think it's coming back. It's coming back with the House bills. It's coming back probably next session in January and February. So I think any time to speak about it is probably an appropriate time. I had a question one time in nursing school, and the question was about what's the appropriate way to treat a patient's pain. And I got the question wrong, because the answer to the question is the first thing you do when treating a patient's pain is to believe the patient. So I hear the pain that everyone speaks. I hear the pain from this side and from that side, and I sit back here right in the middle, number 40 of 40, happy to be here, taking it all in. Thinking of myself, well, gosh, I probably should have gone to law school. Some of these arguments would have made more sense. But we have a wonderful group who represents both sides very, very well. But, every career has room for improvement. I come from the world of healthcare, where we spend years doing evidence-based just research and coming up with evidence-based practices that we can implement patient care safely and most effectively. I also come from the world of aviation, where that world, especially naval aviation, is constantly changing on a daily basis just to make things better and safer. But in all of the worlds I come from, at least, the one thing that we do is we include people to the table. People have a seat at the table who are stakeholders in the room for improvement. I feel like we haven't done that so much with our law enforcement officers. And I say that, last session, January and February, we had Senate Bill 915. It was the senator from Western Fairfax's bill. It was the cosmetology bill with the licensing for the cosmetologists. And we had a group of 50 or so, beautiful people show up to the committee meeting for general laws. And I don't think any of us in this room are cosmetologists, so we all sat and we listened to these guys, and they told us, the pros and cons of their cosmetology licensing. And we listened, because none of us are cosmetologists. So, and we debated for, almost 2 hours that day, I think. And by the time we heard both sides of the debate, the bill was tabled, so the bill went away. It was not a good bill. Didn't speak favorably to their career field. But most importantly, we listened to them, and we listened to those people who live in that world. I did a lot of listening this past session because I come from a very specific world, but there's so many things that I don't know about the state and how to run the state of Virginia. So I think it's a piece of kind of what I don't see happening right now. I don't see a lot of us listening. I will say last Friday on September 11th, I was called the night before September 11th by the mayor of Virginia Beach to show up at the jail at the sheriff's office on Friday on the anniversary of the 9/11 attacks. And myself, I went, a couple of House delegates, our city council members, Sheriff Ken Stolley was there, the mayor, but we held kind of a spontaneous press conference. The sheriff down there, as you can probably figure out, is very concerned about his people and his men. So we went down there, and I listened to Ken Stolley talk, who's a wonderful man, great speaker, but he talked about how when he was in session here in the Senate, he was co-patron and patron of some bills that dealt with punishments for hate crimes, punishments for assault on teachers, and one of the bills that he worked on too was the assault bill for law enforcement officers and making all of those things felonies. But then he said to us, he's like, why do we make all of those things felonies, but now we have changed the one for law enforcement to a misdemeanor? It's not a felony. Why us? Why did you pick us out of all those groups? He's like, in 9/11, we were heroes. And he said, in Virginia Beach, even 18 months ago, we had the Virginia Beach shooting, and we were heroes. We couldn't buy a meal in this town. Everywhere we went, people bought our cup of coffee, people opened the doors. He's like, now we get refused service. So, and I stood in that room and I looked at all those people in uniform, and as I looked at kind of the worry on their face, we met them, we talked to them, and they thanked me over and over. And I was not the person to thank. I came to work, I come to this nice job, I get good food, I sit here and have a lovely time. But those guys, when they go to work, that's not what they do. And for them to be thanking me, I just thought that it meant a lot, but it's not the right way. I should be thanking them. We should all be thanking them. A little over a week ago on my drive home on one of our later days, I got stuck in the Bay Bridge traffic, the tunnel traffic going back to Virginia Beach, and there was a lot of stop and go, and I got rear-ended by a guy right outside of Hampton, but I was fine. Don't need a lawyer, thank you, I know. But the guy took off. It was a hit and run. Actually, he ran into my car. I know. But I was fine. But my minivan had a lovely dent, and so I pulled over off the next exit, and there was a maintenance crew there doing some other stuff, and they had called a state patrol for me. And this was the day that the House, the first day when they killed the qualified immunity bill. But the state trooper came after a couple hours of wait, a lot of traffic that day, and we chatted. We went through the police report and whatnot, and then I said, I just came from Richmond, and I just want to tell you thank you. I want to tell you what's happening. As soon as I introduced myself and said who I was, he knew all about it. I didn't have to really say anything else. And he again just stood and said, thank you. Thanks for fighting the fight for us. I said, we are, and I gave my card and Jen Kagan's pen, and we were all good. But it was, I shouldn't be getting thanked by those people. I'm not the one doing the hard job. Those guys are the ones doing the hard job. So I just want to know, I feel everybody's pain. I'm a healthcare provider. again, I believe the patient's pain, right? I believe all of our pains. I hear our frustrations in the room, but I just want to make sure that we're doing it the right way. There's a lot going on in our country right now. This is a country that I love. I think it's a country that is truly good at heart, and I think that people truly do want to do the right thing in most cases. But you know, we need to make sure it's the right change. I hear us talk about change, and I support change. Again, that's how the world goes round. But it has to be the right change. It has to be for the right reasons, and it has to be for the right people. So let's not let our law enforcement down during this time. Let's think of them. I think of their faces that day when I saw them last Friday. So thank you for letting me speak on their behalf. Thanks, Mr. President.
Thank the senator. For what purpose does the senior senator from Fairfax, Senator Saslaw, rise?
Just for some quick announcements.
Senator's the floor.
All right. What there's been a general decision on is for next week. What we're planning on doing is coming in. We're going to come in. We're going to come in Thursday at 1 o'clock and Friday at 1 o'clock. And what I would like, not this coming Thursday or Friday, next week, okay? There are some bills in committees, and I'm going to quickly run through that. It won't take but a second or two. Hopefully, the committee chairs can have their virtual meetings, so when we come back on Thursday, the House bills will be on second reading. When they come out of committee, they come out on second reading, the House, and it's on third reading is where they're amendable. With the exception of the budget, we may be able to get everything cleared, House bills hopefully by Friday, but in order to, it'd be done by Friday. You could do it Thursday if you waive constitutional readings to get to the amendable stage, but that's all right. So count on Thursday, 1 o'clock, Friday at 1 o'clock. Now, in the committees, this is what is currently in committees to get out. It's not a lot. It's a total of 36 bills. Agriculture, none. Commerce and Labor now, that's cleared. Education and Health has 4. Finance and Appropriations has 2. That may include our budget, and may include the bill that we sent up there today. General Laws and Technology, Senator Barker is 7. Judiciary, Senator Edwards, 20. We'll get rid of some because we're going to meet immediately after this. Local Government, 1. Rules, 2. So hopefully...
Mr. Chairman.
Sure.
Senator from Arlington, Senator Favola.
Thank you, Mr. President. Rehab will have 1, the credit sentencing bill. It's in Judiciary. It'll be re-referred to Rehab. So we'll have 1 bill.
All right. So
Thanks, Senator.
Rehabilitation and Social Services will have 1. So hopefully all the committee chairs can arrange with your committees to have virtual meetings so we can, hopefully wrap this thing up with the exception of the budget by the end of next Friday. Okay? So that's my announcement, Mr. President.
Thank the senator. Do any other senators wish to be recognized? Senator from King George, Senator Stewart.
I'm just curious if the gentleman from Fairfax would answer a quick question.
Senator Yield.
I appreciate all that and giving us our schedule here. And when you say wrap it up by next Friday, have we heard any discussion or do you have any information on when the House is going to perhaps hear our bills?
Senator's the floor.
I'm not aware that they've heard anybody's bill.
As far as I know, they have not, and it's information on scheduling from them has not been very forthcoming. That's all I can tell you. Okay? We'll know a whole lot when we come back here next Friday, next Thursday, and if they haven't met on any of our bills, there's no federal law requiring us to get theirs back to them. Okay?
Thank you.
All right.
Thanks, Senator. For what purpose, Senator from James City County, Senator Norman Rise.
Thank you, Mr. President. If the senior senator would yield for a question.
Senator Yield, you have the floor.
Using the syntax of the junior senator from Richmond, don't you agree, sir, that the Senate should not release the House bills and send them back until we do see some movement and consideration from the House of Delegates on our pending legislation? Don't you agree?
Senator has the floor. Senator's microphone is not on yet.
I would pretty much agree with that. Yeah, I thought I indicated that casually. All right.
Thank the Senator. For what purpose, Senator from Hampton, Senator Locke Rise.
Thank you, Mr. President. I have a preliminary schedule of committee meetings from the House. I don't know how wedded this is.
Senator has the floor.
But what this says is on Thursday, tomorrow at 2, no, that's pro forma. Thursday at 3, Health, Welfare, and Institutions will be meeting. Friday at 10, Labor and Commerce. Monday at 10, Public Safety. Monday at 1, General Laws. Tuesday at 1, Courts of Justice.
Thank the Senator. Do any other senators wish to be recognized? Seeing none, the clerk will report any announcements on the desk.
Today, Friday, September the 16th, the Committee on the Judiciary will meet 15 minutes upon adjournment. This meeting will be in the Science Museum, and the public may view the live stream on the General Assembly website. Tomorrow, September the 17th, there are no meetings. Please take any personal items off of your desk because, once again, we have to break down the facility to be used by another party. As a matter of fact, our staff member, Erica Manson, is getting married here Saturday. So, and since this wedding has been canceled once, you don't want to stand in that young woman's way. So Friday, September the 18th, the Committee on General Laws and Technology will meet at 1 p.m., and this is a virtual meeting. 1 p.m., virtual meeting, General Laws and Technology.
Thank you, Madam Clerk. Is there any other business to come before the Senate? Seeing none, I call on the Senator from Portsmouth, Senator Lucas.
Thank you, Mr. President.
Oh, sorry, excuse me, I'm sorry. We're going to go to, I think, Senator Saslaw.
We can't adjourn. Constitutionally, we cannot adjourn. 11:55 next Thursday.
No.
No.
September 24th.
Next.
I would move then, Mr. President, we stand in recess until next Thursday, the 24th at 1 p.m.
11.
She wrote 1. All right, 11:55 p.m. That makes a.m. if that makes everybody happy.
A.m. yes.
And when
Definitely a.m.
when we recess today, we do so in the memory of Lori Lee Brickley.
Thank the Senator. Question is, shall the Senate stand in recess until September the 24th at 11:55 a.m., and that when we do so in the honor and the memory of Lori Lee Brickley. All in favor of the motion will say aye. Those opposed, no. The ayes have it. The Senate stands in recess until September the 24th at 11:55 a.m., and we do so in the honor and the memory of Lori Lee Brickley.